Good morning and welcome to the third day of this quarterly meeting of the California Board of Psychology. I want us to ask all of us to please turn our cell phones and other devices to silent. You may notice board members accessing their laptops or other devices during the meeting. We're using these devices to access the board meeting materials, so we're not surfing the web. And that's in keeping with our attempt to move over to a Paperlike environmentally friendly process. We have allocated time on the agenda for public comment, and we'll ask for public comment in just one moment. I ask that you be respectful of our time constraints and the need to conduct and complete the board's business. If there are several members of the board seeking to do public comment, then we're going to allocate time accordingly so that we can continue ahead with the agenda. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking action on any agenda item. In making public comment, please do not identify any licensee or registrant of the board by name in order to avoid prejudicing future action that may be required of board members in our capacity as a deliberative body in enforcement proceedings. I'd like to call the meeting to order and ask that Ms. Burns please call roll.
Tate.
Here.
Harbsheets.
Here.
Akoibadu. Here. Phillips.
Here.
Fu.
Here.
Horn.
Here.
Bernal.
Thank you.
Quorum established.
Great. We did carry over from yesterday the public comment period, even though it doesn't explicitly mention it here on this day of the agenda. Could we have public comment for items not on the agenda? Is there any public comment for items not on the agenda? Hearing none, we will move ahead. We are going to, unfortunately, say goodbye to one of our beloved and most longstanding members of the Board of Psychology, Ms. Nicole Jones. And I just want to read to you the certificate of appreciation that was prepared for her. Presented by the California Board of Psychology to Nicole J. Jones in recognition of your invaluable contributions to consumer protection, your insightful impact on policy, your articulate command of policy and advocacy, and your leadership as Vice President of the California Board of Psychology from August 10th, 2012. It says to June 1, 2019, but you get the general idea. So let's have a round of applause for Ms. Jones. That's a good point. I know it.
Good morning, Board of Psychology. Thank you, President Phillips, and all the members here. I want to say thank you for the certificate and for the honor. And I just have a few comments, and I know we're mindful of time always, but I just wanted to say, when I was first appointed in August of 2012, the only member that was there was Ms. Akoibadu. And I just want to thank her so much for her guidance, her mentorship for me to help me be, I think, an effective public member. I also want to acknowledge Dr. Erickson, who at the time was president, who appointed me at that meeting the chair of the Policy and Advocacy Committee. Also, I just want to acknowledge it was such a delight to have been able to recommend Ms. Sorick serving on the selection committee with Ms. Linda Starr, who was another outstanding public member who helped me guide me along the way. I also want to acknowledge Dr. Gallardo, who serving on in his capacity, really looking at how we looked at cultural diversity and in equity and in the work that we were doing. I will be remiss if I didn't say how much fun we had on Sundays in licensing committee with Dr. Horn, Dr. Harlem, and Dr. Phillips, actually. It was a very exciting time, and just the thoughtful way we look at issues and policies, it was remarkable. Mr. Fu, it's been a pleasure serving with you as well, and also the new the newer, I shouldn't say new, the newer board members, Dr. Harbsheets and Dr. Tate. It was a pleasure to sit next to you, Dr. Harbsheets, at the last meeting. And I also just want to acknowledge Ms. Bernal. This has been exciting, almost 6 years, and I just want to thank you. I was excited to be appointed by Governor Brown, and I thank the administration for having faith in my ability. And Ms. Marks and the whole legal team have been so helpful. Dag Trombo, I always mess up your name, I apologize. But it's a pleasure to have that kind of insight, and all of the other leadership on your team, Ms. Sorick, Ms. Monterrubio, Ms. Burns, and all the staff members. Mr. Glass-Steagall, and of course, I can't remember John. John, hi, Mr. Burke. I always appreciated him. I'm sorry, I don't want to be informal, but I just want to say thank you very much for this opportunity. And as you move forward, I just want you to just to be reminded of the former board member when I first came on, Dr. Preston, who reminded us to consider rural issues. So Dr. Tate, I'm glad that you're here. And also just all of the work that we've done as Dr. Gallardo encouraged us to just encourage and have dialogue. So you all continue doing a great job. I will watch from time to time on live stream and like on social media. Ms. Bernal will appreciate that with the strategic planning process. But I just want to say thank you so very much. This has been an honor, and it was a wonderful opportunity to represent on the Board of Psychology. So thank you so much. And now it's signed. Joe, I didn't say your name. Oh, you forgot to say my name.
We're now going to move, we're taking things out of order. We've gotten very creative with the agenda over the past 3 days in order to make best use of our time. We're going to move to the DCA executive update, and we have Mr. Castrillo here to lead the way.
Hello. Good morning, folks. Chris Castrillo, Deputy Director for Board and Bureau Services at the Department of Consumer Affairs. Appreciate the opportunity to come and address the board here this morning. So, as I've mentioned to a few of you before we got things started, most recent news from the department is the departure of our director, Mr. Dean Graffilo. He'll definitely be missed. Dean was a great mentor, great leader to not only myself, but everybody on the executive team. With that being said, we have a great team up there at DCA HQ, and we're just going to continue to plug along, business as usual. And we look forward to whenever the time may come for a new director that will work with the administration and agency on ensuring a smooth transition. But, we will continue to operate and serve the board of psychology and all of our other programs at DCA as we have. So we look forward to filling that hole eventually. Another item that I've provided an update for recently is regarding the executive officer salary study. We are continuing to plug away at that. We are intending for an end of April release, which is just literally right around the corner. I'm anticipating a proposed final draft on that in my inbox today. It'll be my charge to then kind of run that up the chain through agency and governor's office, help explain kind of what's in there, and then of course release to our programs. We've heard some interest and are definitely kicking around some other options as opposed to just, hey, here's the report. I would love to get our executive officers either on the phone or in the room, invite board leadership. We want to solicit comments and feedback from this report. The report in and of itself is not a stopping point. It's hopefully, and as it's been intended, a roadmap to how do we evaluate our executive officers, how do we maybe change that process, how do we address maybe some potential inequities within the salary structure itself. So it's been a long time coming. It's about a 6-month report, 6-month project, excuse me. I think we're going to have a great study. I'm really excited for it to come to completion, and then obviously kind of continuing that conversation as we continue to work forward. Couple other just quick items. I think a couple exciting things that are happening at the department, frankly. Early March, our Deputy Director over Information and Technology, Jason Piccioni, has created the Technology Advisory Council. A relatively informal group of folks who can come to provide their time from all of our programs to advise and frankly discuss about what's next in technology and government. Some of it is very practical from the standpoint of we've been working towards getting a number of our programs on for credit card acceptance. So that's one of what I would consider little low-hanging fruit, but we're also looking at big picture things. What's the next big thing in technology and government? How can we, at both the department and our folks at the program, be leveraging new technologies, existing technologies that might make licensing faster, enforcement more efficient? So we're very, very excited about that. It's really kind of a free and open space to kind of explore how we can really take the department kind of into the next, I guess, decade, century, however you might want to describe that. Secondly, it's similar vein. I am absolutely thrilled about this. We have a open data portal now for the department. It's available on the DCA website. We have both licensing statistics and enforcement statistics. It is visual. It has the ability for folks to just download and put it into a PowerPoint, put stats into a PDF. We think it's going to be super beneficial for board staff, board members, for when you all are doing your board materials, to have something that's really what we're going towards is one click, and you all know what your last quarter has looked like, what your last year has looked like. My team, along with our team over at OIS, has been working on doing outreach to the boards to help kind of collect that data and then display it in, again, my opinion, a very visually pleasing and also accessible way. That is going to be a ongoing process. We'll be working with our boards to kind of continue the collection of the data, upload it into the site on a somewhat regular basis, and then obviously having that information available for the public to see. What are licensing times? What are enforcement timelines? What kind of time should I expect if I'm a licensee and I'm looking to get my application turned around? And then obviously helps us do a little bit of quality control and try to identify boards that are doing great things in the field of licensing and enforcement, and then also maybe identify some boards who could use a little help and leverage some of the things that we've been working on in our enforcement and licensing committees to continue, again, progress in the two really key areas of the department that we focus on, and that being licensing and enforcement. And with that, I just wanted to echo, you folks and thank Ms. Jones for her service. It's really, really important to have folks, as you all know, who are willing to serve on our boards. You all do you're on the front lines, and this is a volunteer position. You all donate your time, your energy, and we really sincerely appreciate everybody who decides to take that on. And so, Ms. Jones, we appreciate your service, and obviously that goes for everybody here in front of us today. We appreciate the great work that the Board of Psychology continues to do. And with that, concludes my update, and happy to take any questions that you all might have.
Are there any board comments or questions? Mm-hmm.
It sounds like a lot that you're doing, particularly with technology, going more, taking a look at statistics, enforcement statistics, how long it takes. I'm really happy to see y'all doing that, because that's been something we've been interested in, and it'll really help us taking a look at things and where there might be difficulties and along the pipeline and all like that, I think, if that's what I'm hearing.
Definitely. And this has been, our data governance team just is fantastic. They do a great job. And this has been something that's been in the works for a long time. There's a lot of behind the scenes coding and, getting things ready for prime time. I think that what they've been able to develop is, again, just very easy to access. You can pull it up and it makes sense. This is what a timeline looks like. There's great charts. And then we're working towards being able to effectively pull this data from our boards and get it in a way that's really accessible for you all and your staff. I think like the ability to one-click PDF or a PowerPoint presentation for when you all are going to go through your licensing statistics really makes it easy for you all to hone in on, okay, what's been working, what maybe hasn't been working, and then of course again for the public in terms of they want to be able to know and access and see the data clearly, and that's where we're working towards. Yeah, excited.
Any more questions or comments from the board? Is there any public comment? Well, we really appreciate you getting up so early this morning.
Still waking up.
I hear you.
Thank you.
Me too.
All right.
Have a safe trip back
Yeah, I flew down this morning.
and
Yeah.
a 6:45 a.m. flight.
He knows my itinerary, so thank you.
Thank you very much. Okay. We're now going to move to item number 25 on the agenda. That would be the enforcement report. Ms. Monterrubio?
Good morning. So since our last board meeting, we have hired 2 new enforcement analysts, and the analysts are responsible for analyzing complaints, performing desk investigations, referring cases to the Division of Investigation, reviewing accusations, and negotiating stipulated settlements with the Office of the Attorney General. Since July of 2018, the board has received 715 complaints. All complaints are opened and assigned within 8 days. We have referred 38 cases over to the Office of the Attorney General for formal discipline. We have issued 22 citations, and we currently are monitoring 42 active probationers and 22 told probationers. And of the 42 active probationers, 2 have been referred back to the Attorney General's office for further discipline. Attached to the report is the overview of enforcement statistics as well as the legend. And we did have an enforcement committee meeting in March. And at that meeting, Deputy Attorney General and Board Liaison Joshua Tomplay and Staff Counsel Noreen Marks discussed whether or not the board should consider making certain decisions presidential to provide guidance in prosecuting cases. And under the APA, the Administrative Procedures Act, the board is authorized to designate their decisions or portions of those decisions as presidential, as long as they have similar facts in the case. So I have provided the government code in the report, as well as a sample of precedent decision procedures. This is medical board's sample. I thought maybe we could take a look at that. There's 6 steps total as to whether or not the board would like to consider making decisions presidential. I think this would be the first time that the board would consider a decision. And in the enforcement committee report, we actually have a case, the Lorraine Schreiber case, that I believe we would like to take portions of that decision and make presidential. And Joshua did provide a memo for the board that everybody should have received a copy of as of yesterday. So we can discuss that case at the time, or we can talk a little bit about it now if the board would like. I think because it's in the enforcement committee report and we actually have a case to discuss, it might be best to talk about everything at that time, if that's okay. So that's the end of my report. If there's any questions, I'm happy to answer.
It's more of a comment. My understanding is in previous reports, there's been a request to articulate what the individual definitions for under the overview of enforcement activity, and I noticed in this report that that was provided, and so just want to thank you for being responsive to the feedback about defining what some of the pieces of that enforcement activity looks like for folks. Really appreciate that.
Oh, you're welcome.
Is there any other board comment? Any public comment?
Wait, I do.
Oh, sorry.
Can you explain in simple terms, I'm going to say, what a precedential Or are we going to take this up later? Okay, never mind.
Okay.
I'll ask. I'll.
Any more board comment or questions? Any public comment? Yes, on.
Good morning. I was also on that 6:45 flight. Yeah, it was early. I'm Dr. Joe Lindercrow. I'm the CEO of the California Psychological Association, and I'm really here to ask the board's guidance on an issue that has been raised by a number of our members, number of your licensees as well. In the most recent issue of your journal, there was a case described that has created quite a lot of confusion for people. And I'm just wondering how we might get some clarification. This was the case of
Please don't mention any names.
what was in the journal.
I know, but please don't mention them in the context of the board.
Okay. It was a case where an individual was found was found guilty of gross negligence. And in the way the case, in the summary, the way it was summarized was that this individual had communicated with clients during and after therapy by email and text. And the way that it is stated in the summary, it says, alleging that the individual engaged in electronic communication, email and text, with the parents of a minor client during and after termination of therapy, which constitutes gross negligence. And so the way that it is stated here could be read as any psychologist that communicates with a patient during or after therapy by email or text is guilty of gross negligence. So this has created quite a lot of questions and concern, and I'm just asking the board's guidance about how we can clarify this, cause quite a lot of conversation on our listserv, and without, I just would like to know, what is your guidance as how we can get a little more information or clarification on this?
Good morning, Dr. Lindercrow.
Hi.
Hi. I just spoke with Ms. Monterrubio as well as Dr. Winkleman, and since this isn't on our agenda, we're happy to have a kind of offline conversation just to follow up on the issue and to give any kind of guidance that we may be able to provide. Ms. Monterrubio will speak with Dr. Winkleman and yourself if you'd like, perhaps during the next available break.
Okay. That's it? Okay. Thank you.
And just to amplify, we want to be sensitive to the licensee that was involved in this and our enforcement procedures in terms of non-prejudicing board members should move on to a different level. So we do really ask that people do not speak about a particular name because we feel it's not appropriate. It can prejudice our determinations at a later point too. But it doesn't exactly apply to this situation, but I want to be respectful of the licensee.
Thank you. Dr. Melody Schaefer, CPA Division 2. I don't know if this is a proper time, but I'd like to at some point ask that this be put to the issue that Dr. Joe Lindercrow brought up, be formally put on the next meeting's agenda so that whatever formal discussion occurs that it could be in the accessible to the public sector, the psychology family as well, since there's so much discourse on this and concerns about it. That will probably help provide clarity. Thank you. Oh, okay.
Any further public comment? Hearing none, we will move on to the Enforcement Committee report.
Very much. Yes. Thank you. So, to wait until everyone gets to item 26 in your packet. Surely. Could everyone get to item 26 in the packet? And what I would like to do is to kind of go back and give a brief summary or history of this particular, of the September meeting that we had, the child custody summary meeting. And out of that child custody summary meeting, and we got to the March meeting, but I would like to kind of go back and do that to bring us up to where we are now. And so let me thank you, Mrs. Monterrubio, for such a wonderful report. So everyone is there at the item 26, the Enforcement Committee meeting. So on September, and I'm going to ask you to also, after I've finished talking about that, I'm going to ask you to go to the child custody meeting. There is the stakeholders meeting report, summary report that is also in your binder that we're going to look at that briefly, that talks about the child custody meeting. So I'm going to start out by the child custody summary report on September the 21st, 2018, the Board of Psychology and the BBS, the Board of Behavioral Sciences, held a child custody stakeholder meeting in Sacramento. And out of that meeting, the stakeholders were invited to participate in the meeting to discuss concerns from the Center for Judicial Excellence. And so out of that particular meeting, we also had an enforcement committee meeting marched also. So what I'm going to ask you to do at this time, in your packet you have the, if you will scroll down to the child custody stakeholders meeting, and if you could just scroll down to page 3, that talks about child custody meeting. And it's going to give us a synopsis of why that meeting came about. And I'm going to ask that we take a few minutes, a couple of minutes, just to read that about the Board of Psychology and the BBS hosted the stakeholders meeting. And while you're looking at that and reviewing that, it's called the child custody meeting. You scroll down, it's in our packet. That will give us a historical framework for why we're doing what we're doing. I want to thank the Board of Psychology, the staff in particular, for putting all of this together, for putting the survey together, calling the meeting, inviting. I want to thank both of the boards. The staff in the Department of Psychology did an excellent job of putting this together, of getting us to this point to answer questions, and we trust that it has done what it's supposed to do. So this is what I wanted us to look at. So out of this, and we can see the boards hosted the stakeholder meeting with the purpose of, and you can see the purposes that are listed there. Okay. So going back to the Enforcement Committee. Now I'm going back to the Enforcement Committee report, and I'm looking at item 1, which gets us to the March 2019 meeting, and out of that March 2019 meeting. came 3 items that we're going to look at today. And those 3 items that we're going to ask the board to take into consideration and approve those. And we're going to discuss them before we do that. So I'm back at the Enforcement Committee meeting in March 29 to discuss then out of that summary meeting of the 21st, came to discuss the child custody summary report, the guidelines for petition hearings, the consideration of designation of the decision in the matter of the citation and fine against Ms. Schreiber, and that's the case that's talking about the precedential decisions. Okay. Are we clear on what we're doing and what we're looking at? And I noticed that Dr. Horn had asked the question about the precedential hearings. Before we ask Mr. Templey to begin to discuss that, there was a letter that he crafted. And this letter, and I'm asking everyone to take, even before, just get the letter out. And what I'm going to ask us to do, there's a definition that, even before that, within our report that talks about, it gives a definition of the precedential decision, the definition of it, and all of that. So I would like for us to go and look at that before we even read Mr. Templey's letter.
Just for clarification, we're going to address this all as one thing, or we're going to address this custody stakeholder meeting action items and then the presidential decision? Or I'm just trying to get clarity as to where
we're going. We're going to do it one by one. However, since that was the precedential decision had come up, I wanted to make us aware that there's a definition contained in our materials, also the letter, and so I wanted us to get prepared for moving toward that.
Okay.
Does that make sense?
Yeah, thank you.
Okay. Clear? Okay. And so your letter should be here, and so we will go back and do it one by one. And let me look to the staff. Is that okay, one by one? Sure. But we just want to make you aware that you have that information. Okay, we're good. All right. And so let me just say one more thing, that we are asking the board to approve. Now I'm back at, and thank you, Dr. Phillips, for that. Now I'm back at the Enforcement Committee report, item 26. And now I am at the third paragraph, which talks about the center submitted a list of concerns and proposals, and if you will notice that the enforcement unit staff and management reviewed the prioritization of the list and recommends the following items be implemented. Item 1, where we talk about, and items A, D, and M. Okay. So, and before did you say I'm lost? No, I'm asking. Is everyone clear of the direction that we're going? Okay, thank you. Okay. So, all right. So I would like to, at this point, let's look at the first item that we're going to be talking about, which is, and these are the things that we were asking for, a mandate child abuse, domestic violence for subject matter experts, the screen child custody subject matter experts for parental alienation, and to educate the public on clear and convincing evidence. So
if I could,
Madam Chair?
if I could just,
yes.
okay.
I'm going to, yes. Let's.
Is it okay if I just chime in real
Please,
quickly? Okay,
yes.
thank you. As Ms. Akwebadu stated, we had a stakeholders meeting in September of 2018, and the Center for Judicial Excellence provided a list of concerns. And the Board of Psychology as well as the Board of Behavioral Sciences met. And on page 3 of the actual summary report, there is a list of all of the
Yes.
attendees. And it was a very
Thorough.
it was a very thorough report. The meeting went very well. And from that meeting, all of the attendees that were non-DCA employees triaged all of the concerns from the center. And that starts on page 8 of the report through page 9. And after looking at the concerns, enforcement staff met with the committee, and we looked to see what items we could incorporate. And those items are listed in the report as item A, which is to mandate child abuse, domestic abuse, violence for subject matter experts. We are going to now require that each expert who reviews child custody cases have 6 hours of training in domestic abuse and child abuse. The second item is item D, and that's to screen child custody subject matter experts for parental alienation. And we're going to work with some of our existing experts to come up with questions for our current experts and any new experts that we look to hire in the future. And then item M is to educate the public on clear and convincing evidence. About a year ago, the Attorney General's office provided an overview at one of our board meetings, and Ms. Gloria Castro provided an overview of what clear and convincing evidence is. So we're actually going to provide a link to that overview and put it on our consumer page on our website. So everyone who's going to file a complaint can click that link on and have a better understanding of what clear and convincing evidence means. In addition to these 3 items, we are also going to prepare a fact sheet, which talks about complaints, timeframes, documentation that's needed to file a complaint and get an investigation initiated. We're also going to work with the Office of the Attorney General to review statutory language to see if we can obtain mental health records without having to do subpoena enforcement. So hopefully that provides a little more clarification as to what we did in March at our enforcement committee meeting. Are there any questions? Yes.
So I might not have heard you, but when you say screen child custody subject matter experts for parental alienation, what do you mean screen them for parental alienation? They understand it? What are you saying there?
Well, that way they do understand it, but I don't believe we're looking for, oh, yes, go ahead, Dr. Phillips.
So what we're screening for are people that are adherents of the parental alienation syndrome. And in particular, people that take an advocacy position relative to parental alienation syndrome, who may be among our subject matter experts. Because generally, with an adherence to that particular theory, which is not accepted in the broader psychology community, there come predetermined results as to who should obtain custody, and we want to make sure that that's not influencing our subject matter experts.
No, that's good. It just wasn't clear here, so thanks.
I just have a question, and it may have come up as part of when you were meeting with the stakeholders. So if a psychologist is, if you are investigating them, they can still continue to practice. Is that correct?
During an investigation, yes, they're entitled to due process. So if we are investigating a complaint against any of the psychologists, they can continue to practice. If we impose discipline where there's a restriction for, let's say, patient population, they're going to have obviously some restrictions on their license. But during an investigation, you can continue to practice.
So that did come up, though the stakeholders were informed and aware. And
I don't know if that was discussed specifically at that meeting, but I know that I've had discussions with some of the individuals that have, attended our meetings, and I have explained the process. But again, everyone is entitled to due process. So because anyone can file a complaint, a disgruntled employee, an ex-spouse, we have to be able to investigate, determine whether or not there's validity to that complaint. So during that process, again, they can continue to practice.
Yeah, okay, thank you.
Sure.
If I might just add, there are occasions in which the board might seek some kind of interim suspension order or an order in criminal court, but those are relatively uncommon. But I just want to add there are certain circumstances in which there will be some kind of order that prohibits the practice while the investigation and the disciplinary process is continuing.
This might be a question for Ms. Monterrubio or the Enforcement Committee. I noticed there are 13 items in that document, and so the 3 items selected before us, those items were selected because we have jurisdiction over them, is that correct?
Correct.
And those 13 items, not all of them fall within our jurisdictional authority, is that correct?
That's correct.
Understood. Thank you so much.
All right. No other comments. So now we will, yes.
We need to entertain a motion.
Yes,
So I don't know if someone would like to make the motion or you'd like to make the motion.
okay. Are there any other, before we go? Before public comment? Okay, okay. All right. Would someone like to move forward a motion that we accept these 3 items, that we adopt these 5 items?
I move
Let
that.
me, before you, let me just, thank you, Dr. Horn, but before you move forward, yeah, that's what I'm wondering.
Saying that we were going to hold the discussion on Shriver and the
Just the 3.
presidential decision as
Okay.
something discrete, so I don't think we,
Have discussed the other 3. Okay.
the first 3 would
3.
be the subject of the motion.
Okay. So the first 3 items that we've talked about, items A, D, and M, that we've just discussed.
I
We're having a
move
motion,
that-
so-
I move.
Wait, excuse me.
Sorry, just to clarify, on the memo, under action requested, the first 3 items, number 1 incorporates 3 of the recommendations from the summary report. Number 2 is to allow staff to work with the Office of the Attorney General on possible statutory change regarding how mental health records can be obtained. And then number 3 is create and post a fact sheet on the board's website. And
So-
then also, did we want to add a 4th, the post information on the clear and convincing evidence, or was that the fact sheet?
That was the fact sheet.
Okay, so just those first 3, I just wanted to clarify, the first one incorporated the 3, and then you have the additional 2 other items.
That we're going to discuss. Okay, are we clear? And let me just wait and let everyone get to that, where it says action items requested, just what Mrs. Sorick has read. Under action requested, the board must decide whether to, and those 1, 2, 3 items that are there. Okay, are we there?
Why don't we entertain a motion while people are reading that?
But
I-
I would like to let them read it and then do the motion. Just give them a couple of minutes just to look at it, so we're all on the same page. And if, when you're ready to move, you may, the motion. Okay.
I move that we accept items 1, 2, and 3 under action requested in the what's the name of it? The Child Custody Summary Report.
May I have a second?
Second.
It has moved and seconded that the board will accept the first 3 items in the child custody, summary custody report. Are there any discussions? Okay.
A quick clarification, the motion is for accepting items 1, 2, 3 in the child custody report, but I believe the agenda item is Enforcement Committee Report, item
Enforcement.
26. So just would like to clarify that we are accepting recommended actions 1, 2, and 3 in item 26 for the committee report.
Very well. Thank you.
Just for the record, did you want to quick, give a bullet for 1, 2, and 3, so the record is very clear for people who are potentially watching but don't have the materials in front of them.
Happy to, but I would defer to the motion makers to do that, as to defer to that.
I will read them. Item 1, accept or deny the committee's recommendation to implement item A, D, and M from the Child Custody Summary Report. Number 2, allow staff to work with the Office of the Attorney General on a possible statutory change regarding how mental health records can be obtained. And number 3, create and post a fact sheet on the board's website.
Okay, have it.
So up to the for board discussion.
Yeah, okay. Yeah. Discussion? Hearing none. Call for the vote. Oh, thank you. That was public comment, please. Yes.
I got it.
I saw in the material that you had in item 26 that the BBS brought up some comments that had come up regarding release of patient records. And something that sounded a bit litigious, that there would be some kind of reaction if the psychologist, I assume in their case, MFT, did not release the records. And I assume that when the board is working with these various divisions and departments, to keep in mind that if one is conducting some kind of an evaluation with a patient or one of the patients involved in a child custody, and they refuse to give permission to release those records, then if the board or any other entity demands release of those records and there's some consequence if one does not release the records, then I would encourage whomever is working with these groups to discuss how the regulations would best possibly include something that would protect the psychologist against legal action by the patient when forced to produce those records when the patient is refusing to give approval for release, if that makes sense. Something similar to the protection that's given when we make child abuse reports and such. Thank you.
Any other public comment? Hearing none, we will move to the vote.
Okay. Tate?
I made it. Oh, aye.
Harb Sheets?
Aye.
Akwe-Badu?
Aye.
Phillips?
Aye.
Fu?
Aye.
Horn?
Aye.
Bernal?
Aye.
Motion passes.
Thank you. Now we will move on to, anything else? Anything else, Mrs. Monterrubio?
Not for that item, but the next item is the guideline for petition hearings.
So we will look at the guideline for hearing. Okay. I am getting there. Okay, the guidelines for petition hearing. Okay, and would you please look at that? Okay, Mrs. Monterrubio, would you like to?
Sure. So board members have inquired as to whether the Office of the Attorney General should make a recommendation to grant or deny petitions for every petition hearing. And at the Enforcement Committee meeting, Deputy Attorney General Liaison Joshua Tomplay stated that the board staff should encourage the Office of the Attorney General to make a recommendation, but that the OAG does not represent the Board of Psychology. They represent the people of the state of California. If the board would like staff to request the assigned Deputy Attorney General make recommendation at the hearing, board staff will let the DAG know. So I have attached our actual petition procedures. And item 11 does state, the board encourages the DAG to recommend whether to grant or deny the petition in petition for reinstatement cases. So most of you have attended petition hearings, and at times the Attorney General's office will make a recommendation to grant or deny the petition. And board members have approached me and asked, why does it sometimes happen and sometimes not? So I just wanted to get a better understanding from the board as to whether or not you would like board staff to encourage the Attorney General's office to make a recommendation to grant or deny at every petition hearing. So the action requested is item number 4, and that is request that the OAG make a recommendation to grant or deny a petition at every hearing.
So moved.
Second.
And for everyone's edification, since we tend to use acronyms in state government, OAG stands for the Office of the Attorney General. DAG stands for Deputy Attorney General, just so that everybody can keep up to speed as to what we're discussing.
I have a question.
Yes.
So I wasn't one who asked about this, and it hasn't. So I'd like to hear from those who would like to hear this every time, kind of what your thinking is, and I mean, what the pros and cons are. It doesn't seem like that big of a thing, so I just want to know.
I'm not sure if I was one of the folks who've asked Ms. Monterrubio, but I certainly appreciate hearing that. I know in our last 2 days with petition hearings, it's helpful to hear from the Deputy Attorney General's perspective, who's representing on behalf of the people, what their thoughts and opinions are based on the facts before them and based on the evidence that they've submitted, and also based on their cross-examination during the hearing. I find that really helpful because in many ways, both the petitioner and the Deputy Attorney General are presenting a piece of the puzzle, and sometimes it's helpful to hear from both sides what that bigger picture looks like. So that's my preference, and that's why I made the motion.
I would echo that on the bigger picture. I think they've had more time with the case, so they might have a greater depth of understanding with that length of time and additional information. So I found it would be helpful.
I just wanted to comment for some of the newer members that I think in the past, what I've heard from the Deputy Attorney Generals who are representing the state is that they have indicated they are neutral. And I've wondered whether or not they are neutral, that they do have a client. It is the state of California. And so I think I was one of the people who kind of raised the issue of they do have a perspective, and it might be helpful to hear it.
I think an additional comment on my end is that to reflect Ms. Mark's comment just now is though it's not necessarily an adversarial role always in front of the petition hearings where, you know, in just the last 2 days we've had situations where the Deputy Attorney General has stated that the facts do align with the evaluation criteria, and so it's not always a yes or no, and that's helpful. And because of that, I find it really helpful to hear from the Deputy Attorney General with the recommendation for that reason.
And without going into the specifics, what the state's position is, to some extent, also influences the discussion that we have in closed session in terms of procedural posture of the case. So I think it's useful information to have.
I would agree that the information is invaluable, and even though I'm a newer member, that information is very helpful for me, especially in closed session.
Thank you. No, I just hadn't ever thought of it one way or the other, and that's really all. I was just kind of like, what went into that? So I think it's a good idea.
Mr. Fu, I just wanted to follow up on what you said. That's right. And what to be more specific, what I've heard a couple DAGs say is that they are not that they are neutral, that they have no recommendation, but they are a neutral party. And I don't see them as neutral. I see them as having a client, and that they are doing more than simply presenting the evidence. So, but you're absolutely right. It's not necessarily adversarial.
Any other comments from board members? Okay. The motion is on the floor, and
Yes.
any public comments?
Hi, Josh Tomplay, the board's liaison to the Health Quality Enforcement section. That's the section, of course, that prosecutes these cases. And I'm just pleased to hear that you found my colleagues' presentation of evidence and recommendations helpful at the petition hearings. Those hearings are different than what we usually do because, as you've said, we appear not on behalf of the board as our client, but on behalf of the people of the United States, of California. Different job. And Ms. Marks makes a good point. We're not neutral in that capacity. Of course, we have a client. It's just a different, more general client, the state of California. So thank you for appreciating our role in that context. Doesn't quite align with the board's, but I think, as you've agreed, we still have a useful role to play. And I've encouraged, and our management has encouraged DAGs to make a recommendation to the board. Of course, I think the board would find that helpful. In some cases, we may not be able to make a recommendation, and please bear with us in those cases, but our DAGs do know that you find that helpful, and so we strive to make a recommendation in every case, and I think the revised guidelines reflect that what we know about the board, they want a recommendation if possible. So thank you.
Thank you, Mr. Tippett. Are there any other comments from the public? Hearing none, we will move forward with the motion. Other public comment? No, that's what I'm saying. I asked public comment. Hearing no other public comments.
Ms. Aguibadu, may I make one more board comment?
Please, yes.
Thank you so much. I speak for myself, but I do want to clarify that while I'm interested in hearing the recommendation, it's certainly something that we take under advisement, and that it's not, and we assess that within the larger body of evidence and within the context of the hearing as well. And so we really appreciate that the strive towards making that recommendation to us, but we also, from my perspective, take that under advisement. So appreciate that balancing act that we do there. So thank you, Ms. Aguibadu.
Quite welcome. Any other comments? Now, it has been moved and seconded. Do we need to repeat the motion? It's been moved and seconded. The request that the OAG make a recommendation to grant or deny a petition at every hearing. Moved and seconded. Call for the vote.
Okay. Tate?
Aye.
Harbsheets?
Aye.
Quabadu?
Aye.
Phillips?
Aye.
Fu?
Aye.
Horn?
Aye.
Bernal?
Aye.
Motion passes.
We will move forward to, are there any other comments or questions? Mrs. Monterrubio, any comments or questions before we move on to action item number 5?
No.
No. Okay. Thank you. Moving on to under action requested, designate the Schreiber case as precedential decision. Now, there was a definition given in our documents. I would like for us to please, before we get to the letter and Mr. Templey's report, I would like for us to look at that. That's already, which gives us a synoptic definition of the precedential decision, what it means, and that is found in in our materials. Yes. But yes. Okay. While I was going to, it is also, it is also in the report as well, coupled with Dr. Harpsheet's. It's a synoptic view right here on our letter as well. So as we're looking, let's take about 5 minutes, please, 2 or 3 minutes, just to review the letter. Okay. Okay. So also, as you're looking at that, you may also scroll down to page, it's the precedent decision procedure, and the document is dated July 2004, and it gives an introduction, the purpose of the policy, and the like. So let's take another 2 or 3 minutes to look at that as well. So along with the letter, and along with the precedent decision procedure, that might also give us further insight into why we're doing.
In light of the
this
fact
step.
that we're taking some additional time to review,
Yes.
I'm going to suggest that we take a 5-minute break now while people are having an opportunity to read that, and so people can make use of the restroom or whatever. We will be breaking at 11:30 for purposes of people that still need to check out of the hotel. Okay? Back to the Enforcement Committee report. Ms. Akwebudu.
Thank you. Just having a meeting all by myself over here in this corner. Thank you very much. Now that we've had an opportunity to look at the procedures and get more information about the precedent decision, the procedures, what it is, and have read the letter, I am going to turn it over to Mr. Temple.
Good morning again. Josh Tomplate with the Health Quality Enforcement Section. I'm happy to try to answer any questions you have about this memo.
Mr. Tomplay, for our benefit, could you just walk us through a little bit the idea behind a precedential decision and why
course.
this is being suggested now?
Yeah, thank you. I think this is exciting for the board. This would be, I believe, the first time that they might make a decision precedential. And in terms of context, why are we talking about a citation case? As it turns out, this is one of the main tools the board has to prosecute the unlicensed practice of psychology. So when the board is investigating the potential unlicensed practice, there's really only 2 tools available. They can issue a citation and order of abatement, and it's that order of abatement that really is the key part. That's the order to stop the unlicensed practice, or they can refer the case for criminal prosecution by a DA's office. So really the main tool the board has to address this problem is through a citation. And this is one of those citation cases, the Schreiber case, and it happens to capture a fact pattern that's one of the main types of unlicensed practice that seems to be out there, which is an individual who practices as a life coach or a life strategist, and in fact that practice encompasses psychology. So this seems to be one of the pretty typical forms of the unlicensed practice of psychology at issue in this case. And we're fortunate to have, I think, a very clear opinion by the ALJ about why this constitutes psychology, why it poses a risk to consumers. And we also have some expert testimony that really came out clearly and in detail that I think if it were made precedential, it would provide some really concrete anchors for future ALJs to use as specific examples. Oh, this has already been found to be the practice of psychology, and they can rely on that in the future.
So it means just saying, as in the case of so-and-so v. so-and-so, that makes it, that's what they're doing, relying on precedent.
Exactly.
Yeah, okay, thanks.
And just again, I don't mean to be a nudge about this. ALJ stands for?
Oh, thank you. That's the administrative law judge that hears the case and writes the proposed decisions that the board then votes on. Thanks.
Can I just make a comment about the particular case? I mean, I agree. I think I'm just glad it's worded so clearly. I think it'll serve as a really nice educational tool. I mean, this case will, just for people who don't understand about the practice of psychology and how one can slip over into that and potentially really cause harm. So it's nice to see it.
Are there any other questions from the board? Yes.
I note with respect to this particular decision that we've decided to take certain paragraphs out of the decision. And in preparing for the meeting, it occurred to me in discussion with board staff and legal counsel, is there any particular reason we can't just certify the whole decision as being precedential?
No, you certainly can. Just from my experience with other boards who have made decisions precedential, one of the reasons you might choose to make, say, only certain paragraphs or pages precedential is just because decisions can be voluminous. This is a pretty short one, so I don't see any practical reason why you wouldn't consider making the whole decision a precedent.
And to follow up with Mr. Tom Play, it's really the one issue of whether or not her conduct is an unlicensed practice, and you might want to just designate certain portions if you had distinct factual or legal issues going on, but I don't see that here.
Yeah, this like Ms. Marks said, this does seem to be a single issue case, really. So I don't think there'll be any confusion if the whole case is made precedential, what the board intended by that.
I don't mean this to be irreverent, but is there any reason why we would not want to do this?
Not that I can think of. If anyone has any questions or concerns, I'm happy to address those, but I'm not aware of a downside to making the decision precedential. Maybe in some decisions, there's certain findings or conclusions that the board believes, accurately illuminates the law, and maybe there are others that aren't so accurate. But in this case, I think it's pretty straightforward, and there's not too many issues here. There's really just the unlicensed practice issues, so I don't see a downside.
Thank you.
Yes.
Madam Chair, if I may, I would like to make a motion to designate the Schreiber case as a precedential decision for the Board of Psychology.
I'll second that. It has been moved and seconded that the entire Schreiber case be designated as a precedential case. Okay. Do I get may I have a second? Oh, thank you. It's been moved and seconded that the Schreiber case, the entire case, is set as precedential. Are there any questions, further discussion?
I just think this is a really helpful thing to do, particularly not only for the administrative law judges, but I think it can also potentially give guidance to people that perhaps are practicing in related fields as to when they stray into our territory that would be specifically restricted to our scope of practice. And I think it's also helpful for licensees to be able to see it in order to determine whether they want to, for instance, make a board complaint against it. So I think on a variety of different levels, this is just really good concrete information for people to have. And it is a really clean case. There's not a lot of extraneous things or erroneous statements made. So I think we're very safe in doing this personally.
Thank you. Any other comments from the board? Public? Did you, no, he's going to do the board first. Any other comments from the board? Thank you very much. Public? Thank you. Public comment? Seeing none, hearing none, we will move forward to the vote. May I?
Okay. Tate.
Aye.
Harbsheets.
Aye.
Akwebudu.
Aye.
Phillips.
Aye.
Fu.
Aye.
Horn.
Aye.
Bernal.
Aye.
Motion passes.
Thank you. The motion now passes. Okay. Before we, Mrs. Monterrubio, any comments, questions?
No.
Thank you so much. Mr. Templey, I hope I'm saying your name correctly. Mr. Templey, any questions, concerns, comments?
No, thank you.
Okay. The committee members. Member.
Not at this moment, Madam Chair.
Mrs. Marks. Good. Mrs. Sorik. No. And I do that because part of the committee. Let me just thank all of you all for participating in moving this information forward. And I just want to thank you again for being able to get through our action items with a high level of clarity. Thank you all for just jumping in and moving forward. I thank you for that. So on that note, I am going to, this will be my last enforcement meeting. I'm trusting that the enforcement is the other matters will be shepherded through by Dr. Phillips until there is a replacement. When we trust it will be, and it'll move forward. So the enforcement committee is in excellent, and I do mean excellent hands. Thank you all.
I did want to, and thank you very much for all your service on the board over all these years and for your stellar job leading the enforcement committee.
Yeah.
She's the most fun committee chair ever. So I did want to provide an opportunity. I saw that additional members of the public came in during the enforcement committee report. Yes. Did you want to do it? Or? Yes. Oh, go ahead.
Thank you. This is exactly what I'm saying. As my mom, I mean, yes. Thank you again. Yes, there was one other item. We want to open it up to for the public, and so if we have other public comment, please come forward. And we're going to time constraints on this one. I know I didn't do that previously. So 5 minutes for public comment. Thank you very much.
Thank you, Madam Chair of the subcommittee or committee and members of the board. My name is Kathleen Russell with the Center for Judicial Excellence, and I am sorry that I missed the presentation you gave this morning. It was on the agenda for this afternoon, and so I appreciate being briefed during the break by Ms. Monterrubio about what the Enforcement Committee has officially decided to do as a result of our stakeholder meeting last fall. I did, and I'll watch the video of that discussion after the fact, so my comments are a very cursory understanding of what's written here on your agenda. First, I want to thank the board for taking what appears to be meaningful action in response to the stakeholder meeting, and I think it's been 2 or 3 years now of public education of board members by us about the crisis in the family court system, particularly related to your licensees who are using junk science, parental alienation to place children into dangerous situations with parents that they've identified as sexually or physically abusing them. So mandating child abuse and domestic violence training for your subject matter experts is a wonderful step in the right direction. I see that that would be 6 hours each, and I don't know if this was discussed, and maybe we can dialogue if there's time, but I think it's crucial to know who would be conducting these trainings and what their orientation is, what their qualifications are. We know that there are parental alienation-based experts that are doing judicial trainings through the Judicial Council. That obviously would defeat the purpose of this change if those conducting these trainings are steeped in parental alienation. I also wonder just when these trainings would begin and if they would include your current subject matter experts, or are they only for incoming SMEs? I would hope that they would apply to both. And I don't know if there's an annual or biannual ongoing training that could be done as well. Screening your child custody subject matter experts for parental alienation, excellent. Really, really pleased to see that. But I guess I'm curious what that means in practice. Will people who are screened and say, yes, parental alienation is a scourge in California and needs to be dealt with, removed from duty as subject matter experts, or what does that mean to screen for that, I guess is the question. And again, hope that this would include existing subject matter experts in addition to new and incoming experts. And then the educating the public on the clear and convincing evidence standard, I think, is really an important priority for this board, and I'm thrilled to see that my understanding is the board will be working in collaboration with the Attorney General's office on possible statutory language to try to get around the lengthy and difficult process around subpoena enforcement for mental health records. So if that helps to streamline these complaints in any way, then I think it's a very good move forward. As timing has it, yesterday I wasn't here because our 3-year effort to get the Commission on Judicial Performance audited came to an end with the release of the state auditor's report on the Commission, and I would encourage the board to read this because what this Commission does is quite similar to the Board of Psychology's function in terms of enforcing discipline on judicial officers in the state. And one of the recommendations by the Commission is to engage the public and do more activities focused on public engagement. They specifically recommend posting a complaint on their website that meets the standard for discipline. And I know that's something I've raised in the past, and that certainly falls within this third item about educating the public. I was here when the Attorney General or Assistant Attorney General Gloria Castro made her presentation along with Joshua about what clear and convincing evidence looks like. But the majority of Californians who are filing complaints were not here, likely will not watch the video of that presentation. And there still remain huge gaps in understanding for people trying to file complaints against licensees about exactly what is sufficient for the board to act. And I know at least a dozen complaints that have been filed about certain folks in the last few years that have been denied because of this issue of insufficient evidence.
Okay, Mrs. Russell, just can you
Sure.
bring closure?
One other item, and then I'll be done, is that, as I mentioned to Antoinette and I think a few others, there was last month a national NPR story for an hour on this very issue of parental alienation and reunification programs. It was called Bitter Custody, and it was on the Reveal Radio Hour. So if you go to revealnews.org, you can hear an entire hour-long episode on these issues. And your licensee, Dr. Rebecca Bailey, was quoted in this article, in this story, calling for more regulation of reunification programs. She literally said, "It's the wild, wild west out here, and we need more regulation." Thank you.
Thank you very much for your comments.
And I believe that concludes the enforcement report and the enforcement committee report. Thank you very much for coming, Ms. Russell.
So there's no response to my questions, or how will I get those answered?
Well, you can keep in contact with Ms. Monterrubio. A large number of the issues you're raising are how we're going to operationalize some of these things, and that's going to go back to the enforcement committee and enforcement staff to discuss, and then will be brought back to the board, and there'll be room for further discussion at that point. But I think some of the questions you raise are important ones, and they'll have to be considered in the context of that discussion as to how to do that. I do think that the intention as to people who are advocating for parental alienation syndrome and maybe masquerading as child custody experts, but are really kind of advocates more than being neutral parties. We do intend for that screening, as well as any training, to take into account any expert that wants to get on the panel, I believe, and any expert that and any expert who's renewing on the panel. So some of these requirements will, with renewal cycles for subject matter experts, come into effect.
Okay, thank you. And was there any timeline given for the trainings to begin?
No, and we will.
This could be a year or more. Or?
We don't actually do the training, so we'll have to discuss that again with the enforcement committee. But
okay, thank you very much.
We want to move forward with these items.
Okay, thank you.
Thank you. Oh, sorry. We all fall prey to it. To item number, we're going to move back to item number 22, which is legislative report. We have had a portion of that already disposed of in a prior day of this meeting, but we're going to move on at this point to further discussion.
So we're going to return to item 22A. This is related to the review and consideration of reviews to the goal of the Policy and Advocacy Committee. This is page 85 of your combined documents out of 470. As a recap from yesterday's discussion, the board did unanimously support a change in the committee name from Policy and Advocacy Committee to Legislative and Regulatory Affairs Committee. And then we had the night to sleep on the revised goal, and in particular, there was a question about the last sentence related to how the committee interfaces with the board related to regs. The last suggested change on the table was to rewrite it as, quote, "The committee may also recommend regulations, suggest changes to regulations, and inform the status of regulatory packages to the board." I leave it to the auteurs in the committee to help us refine that last sentence to better reflect our goals there. So, Ms. Sorek?
I have a possible thing for consideration. The committee also informs the board on regulations and the status of regulatory packages. And then that gives you the flexibility as part of the informing to make amendments if necessary, or I don't know if that's inclusive enough.
It seems a little passive, considering that we're actually talking about situations in which we might, I know initiate's the wrong word, where we might draft proposed regulations that don't fall within the bailiwick of any particular committee other than, I want to say policy and advocacy, but it's got a new name. And also to suggest amendments. So I think maybe a more active word there would be helpful. But could you repeat the sentence again?
The committee also recommends and informs the board on regulations and the status of regulatory packages.
Dr. Horn?
But the committee also does recommend. So what does that committee recommend?
We talked about wording, right?
Huh?
Recommends regulatory wording.
I don't know.
Or recommends regulations and amendments to regulations?
That's what we talked about.
Is that right, Ms. Marks? I mean, this is kind of where we got a little stuck the other day, but what accurately reflects what the committee does?
I have another one. The committee may also recommend regulations, amendments to regulations, and inform the board on the status of regulatory packages.
Can you
Ms.
read
Marks?
that again?
Oh, sorry.
So I guess my question is, are certain regulatory packages, are they reviewed within this committee in an ongoing way? In other words, does the committee say, we recommend the board initiate this particular package, and are they the committee that continues to review and wordsmith it? Or does it almost always go to some other committee? Because then we can just talk about the committee recommending initiation.
It depends.
It depends.
I think part of it is the policy, the Legislative and Regulatory Affairs Committee works in collaboration with the other committees on these regulatory packages. I think licensing is a good place, is a good example. Enforcement is another good example of places for that. And at the end of the day, the committee is a product of the board, is a creature of the board in many ways. And so we do what the board wants us to do, and defining that. Our role and responsibility, and I think this would help clarify that and indicate that that we do touch different items. But I understand that, Ms. Sora, could you please repeat the sentence that you had suggested for the benefit of everyone?
The committee may also recommend regulations, amendments to regulations, and to inform the board on the status of regulatory packages.
Would it work to say the committee also recommends regulatory changes and informs the board? Because would that encompass just about any change, an amendment, an initial?
Yeah.
But can I suggest, instead of on regulatory, to say about regulatory?
So, Ms. Sora, if you could provide us the updated changes that Ms. Marks and Dr. Horn provided, as I saw you diligently capturing those statements. Or maybe, Ms. Marks, could you repeat for us what your recommendation is, and then include the prepositional change that Dr. Horn has suggested?
I will try. I did not write it down. The committee also recommends regulatory changes and informs the board
about
the status of regulatory packages. And may I take this opportunity to apologize, because I was at this meeting in March where we discussed this and forgot.
Yeah, we knew it.
Welcome to my world.
Ms. McCochran, did you get that? Because I don't think I.
I'm going to read what I got, and
Okay.
maybe that will help. And I think I have Dr. Horns on instead of about. So the committee also recommends, wait, oh, what?
It's about.
Oh, so put it back, okay. See, there we go. The committee also recommends regulatory changes and informs the board about the status of regulatory packages. Clean and no extra commas needed.
So that last sentence is within the larger context of the revised goal before you, which we didn't hear any comments beforehand. So,
Chair, would you like me to read that for everyone?
yes, that would be great. Thanks,
Okay.
Ms. Burns.
So the newly named Legislative and Regulatory Affairs Committee goal would be, the goal of this committee is to advocate for legislation and develop regulations that provide for the protection of consumers' health and safety. The committee reviews, monitors, and recommends positions on legislation that affect the board, consumers, and the profession of psychology. The committee also recommends regulatory changes and informs the board about the status of regulatory packages.
Is there a motion from?
So moved.
So we have a motion from Dr. Harpsheets and a second from Ms. Akwebudu. Is there public comment? Seeing and hearing none. Additional board discussion? Ms. McCochran, could you please call the roll?
Just to clarify, it was motion by Harbsheets and seconded by Akwebudu?
That's correct.
Okay, thank you. Okay, so Tate? Aye. Harbsheets?
Aye.
Akwebudu?
Aye.
Phillips?
Aye.
Fu?
Aye.
Horn?
Aye.
Bernal? Motion passes.
Great. Wonderful, thank you. Which now gives me license to write the update in our journal that is due to Ms. Sorek by the end of today. So, or Monday. So the next item under section 22, and as Dr. Phillips alluded to, we have been efficient in our agenda and we've been moving at a clip pace. So just to recap yesterday, we have already reviewed items C to E, D through EE, and we've covered all of items in section 3. So that leaves us with the following. Under 22C1A, which I will give you a page number, which is
97.
97, because we know apparently Macs are faster than PCs according to Dr. Horn. This bill is, so this is item 22C1A, Assembly Bill 544, related to inactive license fees. The board has, the staff has recommended to the board to consider taking a position on this bill. This bill was not heard before the Legislative and Regulatory Affairs Committee due to timing in March. So I'll turn it over to Ms. Burns for an update and questions for the board.
Absolutely. So AB 544 would prohibit boards under the Department of Consumer Affairs from requiring payment of all accrued and unpaid renewal fees and delinquency fees when they have an expired license or registration. It also would limit the maximum renewal fee for an inactive to 50% of the license. The cost of your license. Our board already has a significantly lower inactive fee, so that's not relevant to our board. However, the payment of unaccrued renewal fees and delinquency fees, that is currently something that the board does. So currently that would affect the board. It would be a minimal cost impact due to the overall budget and the fact that our inactive renewal fee, which is usually where this comes into play, is so low. But for other boards within DCA, this does have a significant impact because some of the other boards do not have a significantly lower or even lower inactive fee. Their inactive and active fee is the exact same price, which is not true for our board. So you pay a $400 renewal fee plus $30, which is a CE, and then a mental health fund fee that's on top of that. But for inactives, if you're not practicing, you pay the $40 plus the education fund. So our board is different than a lot of other boards in that our inactive fee is significantly lower. There is the additional clarification, since we reached out to the author's office to get technical clarification. The author's office really wanted this to be for those leaving the practice for issues such as illness. You're leaving to go raise children after a pregnancy, and then you return to the profession later. Currently, right now under statute, if you have an expired license, so say you went inactive and then you expired, if you expire and you do not renew, at 3 years, it will automatically cancel, and that's a statutory provision. So at that 36-month mark, your license will cancel. You will have to reapply. And then those reapplication provisions, licensing takes care of in that end. So currently, it's in your analysis. They're trying to look at ways to revise those provisions to meet this, but the author didn't intend that if you went inactive and you were intending to stay inactive, but oops, you forgot to renew, that you could come back without having to pay all your fees. So they're trying to clarify what they meant, because I think they didn't quite understand that many of us do have inactive fees and the way it works. So they are working on that. It was heard on 423 in Assembly BMP, and it did pass out of there. But they still plan to be working with boards on clarifying amendments. So they're trying to narrow this down to a smaller group that wouldn't have to pay significant fees, and how that might operate. So that is kind of the update on how it is, where it's at. The analysis is for your consideration and for your discussion, whether or not the board would like to take a position or not.
Are there any questions for Ms. Burns?
So y'all are recommending we take a position?
We would
Staff
like you
is?
to have a discussion on this. There's two parts of this. Essentially, should they have to pay their fees, and is paying fees part of your responsibility as a licensee or a licensee's responsibility for maintaining their license? There's kind of a principal component, and then there's also a loss of fees, but we're not really all that concerned about the loss of fees as compared to the responsibility to maintain your license. For some other boards, this is very different for them, and that's a big hit on their budget. For us, this is not a monetary concern.
I think it really depends on how this bill gets amended and clarified as to which group of people are going to be able to do this. I do think licensees in general have a responsibility to pay their fees, and if they don't pay their fees after a certain period of time, then their license is no longer active and expires. But there are also extraordinary situations, particularly with the number of women, for instance, in the field that I think often do go out for maternity leave and sometimes do need to have interrupt the time during which they practice. That's a very different situation. I don't know if we want to watch it or we want to take a support if amended, or because it feels so amorphous to me.
I agree. I don't know what I would want to do, but it feels too amorphous at this point in time. You know, they say what their intention is. They say they are going to change it, but we haven't seen what it gets changed to. So, you know, I don't know that I want to support if amended, you know.
Until I see it.
Exactly. So.
Is it possible for us to watch with great interest or watch and authorize staff to work with the author's office?
Absolutely, and to convey your concerns. You also have the option of a letter of concern. So you have a variety of options here. I think allowing us to work with the author on technical concerns, if I know exactly what they are, can help craft that. There is the principle of using the broad brush to paint all boards, and that's what this bill does, again, like other bills we have seen in the past and have been problematic. But they are trying to understand where we do have an inactive option that is relatively low cost to the licensee and easy to maintain. That there's a variety of things we can do. We can continue watching it and then raise the concern that we believe licensees should maintain and should stay inactive, but that there maybe should be some safeguard for those that have forgotten. Ours would also be different than other boards, that we do have an automatic cancellation provision in our statute. So that 3-year mark, it hits people anyways. So other boards, they can be expired for much longer and their license doesn't get canceled. So, I mean, Ours is rather rare compared to the other boards that are in this bill.
Based on what you're saying, it seems to me that something like a letter of concern that outlines the particular areas in which we're impacted so that they will have that information and will be an entree for you to work with them to the extent that it needs to be amended to minimize the impact on board operations and at the same time recognizes these needs that the author's intending to address.
Dr. Tate, do you have a comment? No, I saw your finger hover over, so I thought I was trying to cue you up. But Ms. Marks.
Yeah, I do. I do have a question, Ms. Burns, about how it works. Let's say a licensee renews in an inactive status, but then wants to reactivate prior to the next renewal date. What's the renewal fee?
It's a prorated fee. I don't want to quote a number, but I want to say it's $17.76. Okay, there you go.
$16.67 per month left in this cycle, and then on top of that, we just add the $10 the
CE audit
fee.
So when you've gone inactive, you've paid your $40 plus the mental health fund fee to renew inactive, and say, I don't know, 9 months in, you decide, you know what, never mind, I'm actually not going to take this sabbatical or whatever you were planning to do. I'm going to come on back. You go ahead and you go online, you download the reactivation form, you fill it out, and you pay that prorated amount to reactivate. But you also, because there is the competency maintenance there, you are going to need to verify, and our wonderful CE auditor, Ms. McCochran, is going to audit to make sure you've had 36 hours, including 9 live, in the last 2 years preceding that application. So unlike your normal renewal, which is within your renewal cycle, you're going to have 2 years from the date of that application. So it's a little bit of an offset for CE, but it's to make sure that within the 2 years before that application, you have met your continued competency. Is the other question part of that? Okay.
Is there additional board discussion? What I'm hearing sounds like there is an interest in developing a letter of concerns, and so the potential path forward would be to delegate to staff to develop a letter of concerns, and I would say work with the chair of the Legislative and Regulatory Affairs Committee on the letter, and submit that to the author's office with relation to the board operations. And I do want to note that we have a committee meeting on July 8th in Sacramento, so that will be another opportunity for the committee to review and get more information if there are potential amendments. And once that letter is finalized, before that, I think we can then send to the entire board for reference. But I think that's where potentially we would go forward. Ms. Sorik?
I just also wanted to add that I saw in the committee analysis for the Assembly Business and Professions Committee that the Department of Consumer Affairs is on record as opposing the bill, which the department doesn't always. It's fairly rare that they come out this early in the process to take a position on legislation, because you have to go through a process of approval to get the administration to kind of allow you to be on record as being public on a position. So I'd like to ask Mr. Castrillo, I don't know if he's, okay. We can reach out to DCA and make sure that there's a representative that comes to the next Legislative and Regulatory Affairs Committee. And that way they can articulate what their concerns were, because in the analysis it was just the Speech Pathology, Audiology, and Hearing Aids Board that had kind of an articulated opposition in the analysis, and the department was not represented. It just was opposition. So I just want to know what their concerns are, and that way it can help us or inform us in our discussion.
So that's really helpful, Ms. Sorik. And so it sounds like what motion would be on the floor potentially would be to delegate to staff to develop a letter of concerns in consultation with the chair of the Legislative and Regulatory Affairs Committee to share with the author any impact on border operations. Is that, yes, Dr. Horn?
I have a question. In that, would you want to bring it back to your committee when we also have the input from DCA before it goes forward anymore?
Do you mean the letter, or do you mean?
The letter.
I think timing-wise, I'm assuming the letter would go out sometime in mid-May. And the committee isn't meeting until July 8th. And so my concern would be getting that letter to the author's office too late in the process.
Yeah.
And it's a letter of concerns isn't taking a position. We're not saying we're opposing the bill, though obviously the department is. But
We're
I
just
think
expressing these are some things as we read it currently that we have concerns about.
And that wouldn't prevent us from determining why the department has taken its position while in the process of drafting the letter, correct?
We can reach out.
And I would assume that staff will work closely with the department's legislative liaison to make sure that our letter is aligned with, or at least consistent with the department's concerns in some ways.
Or at least has mention of.
And mention up, right?
Since our concerns may be different.
Right. So is there a motion to delegate to staff to develop a letter of concerns related to AB 544 and to work and consult with the Legislative and Regulatory Affairs Committee? Is there a motion on the floor for that?
I'll move that. Oh, I'm sorry.
I'll second.
You move it. I'll second.
Whatever works.
So we have a motion by Dr. Tate and a second by Dr. Horn. Is there board discussion about this item or the motion on the floor? Is there public comment? Seeing and hearing none. Additional board discussion? Ms. McCorkin, could you please call the roll?
Sure. Tate?
Aye.
Harbsheets?
Aye.
Akwe-Badu?
Yes.
Phillips?
Aye.
Fu?
Aye.
Horn?
Aye.
Bernal?
Aye.
Motion passes.
Thank you so much. The hour being 11:30, I will turn it back to Dr. Phillips for a potential recess.
Yes. We're going to take a 15-minute recess for purposes of people being able to finalize checking out of the hotel. So we'll return here at about 11:45, and then we'll determine where we go from there, but we will continue with the legislative report. Okay, we're back in session, and I'll turn it back over to Mr. Fu.
Thank you, Dr. Phillips. Before we move on, Ms. Sorek would like to make a clarification regarding AB 544 and the position of the department.
I just wanted to make a clarification that on the committee analysis, that the Department of Consumer Affairs name was listed with a comma, and I think it was just a possessive of the board for speech pathology and audiology board. So I just want to clarify the Department of Consumer Affairs has not taken an opposed position. It is the Department of Consumer Affairs Speech Pathology and Audiology Dispensers Board that took it. So I just wanted to clarify that for the record.
Thank you, Ms. Sorek. So we're going to move on to item 22C1B. This is page 124 of your combined packets. This is Assembly Bill 1145 by Assemblywoman Garcia related to the Child Abuse Neglect Reporting Act. Ms. Burns?
So this bill would clarify Child Abuse Neglect Reporting Act provisions, so CANRA provisions, regarding sexual assault, that it no longer includes any acts including sodomy, oral copulation, or sexual penetration if committed voluntarily, and if there are no indicators of abuse unless the conduct is between a person 21 years of age or older or a minor who is under 16 years of age. So this bill essentially provides for equal treatment of consenting minors under the law regardless of the type of consensual sexual activity. The board has been waiting for quite some time for an AG's opinion that would cover part of this. This obviously would go ahead before that. Currently, it was in Assembly Appropriations on 4/24, and it was postponed by the committee, so we'll continue to update on that. But I think staff would like to recommend taking a support position on this.
I'm very much in favor of us taking a support position on this particular legislation. The child abuse, neglect and reporting laws have tended to differentially impact sexual minority youth as opposed to heterosexual youth. And I think it's important that we recognize that there's all sorts of different forms of sexual expression, some of which may be more common to certain groups, but that shouldn't really determine what the outcome is as to our reporting requirements.
Is there a board discussion related to this item? Dr. Harpsheets?
Just a statement that I also strongly support it.
Additional comments? Is there a public comment related to this item? We can have public. Yeah. Go ahead, Dr. Winkleman. And then I'll ask for a motion.
Hi, Dr. Elizabeth Winkleman with the California Psychological Association. I just wanted to thank the board for considering this bill, and the CPA also supports it and thinks it would bring needed clarity and more fairness to the child abuse reporting. So thank you.
Thank you, Dr. Winkleman. Is there a board motion to support this bill?
I so moved.
We have a motion by Dr. Harpsheets, a second by Ms. Akwebudu to support this bill. Is there additional board comment or discussion? Public comment? Additional public comment? Seeing and hearing none, can we please call the roll?
Tate? Aye. Harpsheets?
Aye.
Akwebudu?
Yes.
Phillips?
Aye.
Fu?
Aye.
Horn?
Aye.
Bernal? Motion passes.
Thank you. Moving on to item C1C, Senate Bill 53 by Senator Wilk. This is a bill that modifies the Bagley-Keene Open Meeting Act and would affect board operations. Staff recommends an opposed position. Ms. Burns?
Sorry. SB 53 Wilk relates to the Bagley-Keene Open Meeting Act. This bill would require any two-member advisory committee of any state body, that would include our board, to hold open public meetings if at least one member of the advisory committee is a member of the larger state body. So that would include even our ad hocs, anything that had a public non-board member at it, plus our board member. Currently, that would also mean anytime we go to a legislative visit, that would be two members talking policy with a legislator. So that would also essentially be a public meeting under this bill. So staff has quite a bit of concern about this. Currently, our two-member advisory committees are all items that they decide are recommendations brought to the full board to have a public conversation about said policies and decisions at a full publicly noticed board meeting. So currently, none of our two-person committees or ad hoc committees can essentially take the kind of action that this bill was meant to address, which was something that the governor and a other state body had done in a prior year. Currently, the board utilizes the two-person format for its enforcement committee. This allows for the protection of our enforcement analysts. We have had threats against enforcement analysts in the past, and which is why we do not share the names of our enforcement analysts. Their participation in the enforcement committee would have to be limited or completely withdrawn under this bill, because then they would be in a public meeting. Their names, obviously, it would be really difficult to have them be enforcement analyst A the entire time and never use a name. And then also there is a face at that point to that enforcement analyst. So for the protection of our enforcement analysts, this bill is really problematic for us. And then there is the other concerns, which I think another board had brought up, that, again, your legislative visits would also fall under this. Your sunset committee of two people that help the board prepare the sunset report, that would also qualify under that. So, again, this is a bill meant to address something else. The bill has previously failed in the past. It's gone to the governor each time, and the Governor Brown would veto the bill. this bill would be going to Governor Newsom. So currently, the board would like to, or staff would like to recommend the opposed position for this bill. Not for the transparency part, which we do agree with transparency with board operations, which is why everything that goes to our advisory committees comes to the full board for a public airing and comment. So,
is there board questions or discussion, Dr. Phillips?
Yeah, this bill is very problematic as far as I'm concerned. Having sat on the enforcement committee, it would totally chill the atmosphere in the room and make it difficult for staff members to attend. And what works about the enforcement committee is the ability to interact with staff and have discussions as to policy and otherwise. And sometimes we're discussing, confidential enforcement cases, so that would make it very difficult. Also, you could be in a situation such as Dr. Horn and I just found ourselves in for different reasons. We were attending the ASBPB conference in Santa Fe, New Mexico, and if there was a substantive discussion in a room where we were both present, that would have to have been publicly noticed for us to both be in the room. Further, it would even maybe put a chilling effect on people having any kind of interaction with other board members outside of even if it was a social engagement, it would feel like it was potentially a violation of the Open Meeting Act. So I just think this is problematic on so many levels that I strongly support the idea that we oppose the statute.
Is there additional board discussion?
No, I would have to echo Dr. Phillips' comment as well. And when you discuss safety of the board staff, that is a priority on my list. So,
is there a motion to recommend to the board? Is there a motion for the board to take an opposed position to Senate Bill 53?
I move that we oppose.
Do I have a second? We have a motion by Ms. Bernal, a second by Ms. Akwebudu. Is there public comment related to this item? Additional board discussion? Yes, Ms. Sorick?
Really quick, I just want to add that if the board supports opposing this bill, we're happy to also reiterate that while transparency is certainly one of the values that the board has identified in its strategic plan, and as much as the board business can be transparent, that we value that and it is a priority. However, in these small number of circumstances, it wouldn't allow us to do the board business and function effectively and efficiently. So I just wanted to kind of make that point to the board.
And as Ms. Burns pointed out earlier, any action, any substantive action that's taken by a committee that operates with 2 people or less, I guess we don't have a committee with 2 people, with less than 2 people, but that would immediately come back to the board at the next board meeting for open discussion. So the transparency value is served at the same time that we're able to better conduct business. Having gone through Sunset Review, for instance, previously, that's a very fluid process with multiple drafts of documents that have to go back and forth, and to have to notice every discussion about that would be completely impractical.
So are you suggesting, Ms. Sork, that that be part of our letter, our opposition letter, that we value transparency and everything, but yeah.
Could you please call the roll?
Sure. Tate?
Aye.
Harbsheets?
Aye.
Akwebudu?
Aye.
Phillips?
Aye.
Fu?
Aye.
Horn?
Aye.
Bernal?
Aye.
Motion passes.
Excellent, thank you. Next on our list, item D, Senate Bill 66, related to federally qualified health centers and rural health clinic services. This bill, I believe the bill has previously supported a version of this bill in a previous legislative session, but Ms. Burns, would you like to provide an update for this?
So SB 66, again, like last year's bill, it would allow for 2 visits at a federally qualified health center or rural health clinic on the same day. Currently, it's only allowed for dental appointments. So if you went to see your physical health doctor for pain in your arm, but you also need a dentist appointment, you can do that. If it is for a mental health reason, you cannot, which just creates additional barriers to care and access. And this is why we supported it previously, to support access to mental health care. And again, staff would like to recommend, or in the Policy and Advocacy Committee also recommends a support position on the bill. Currently, it's on the appropriations suspense file, which means it obviously costs some money. So we'll continue to monitor it, and as it goes through the houses, last year it went all the way through to the governor. I do believe they're trying to make sure it gets into the budget, so that isn't as big of a concern. So we'll continue to watch as it develops.
Thank you, Ms. Burns. Board discussion related to this item? Is there a motion to support the recommendation of the Legislative and Regulatory Affairs Committee to support this bill?
So move.
Is there a second?
Second.
So it's been moved by Dr. Tate and seconded by Dr. Horn that the board supports this bill. Is there public comment related to Senate Bill 66? Dr. Winkleman?
Hi, Elizabeth Winkleman again with the CPA. I just wanted to again thank the board for considering this bill. CPA also supports this and feels it's important for increasing access to needed care, especially for people who have disabilities, mobility issues, or other practical constraints to getting to appointments when they're both needed. So thank you.
Thank you. Any additional public comment? Seeing and hearing none, board discussion. Ms. McCord, thank you.
Tate,
Aye.
Harbsheets,
Aye.
Akwe-Badu,
Aye.
Phillips,
Aye.
Fu,
Aye.
Horn,
Aye.
Bernal.
Aye.
Motion passes.
Thank you. Next item is item E, Senate Bill 425 by Senator Hill related to healthcare practitioners. The staff is recommending a support position on this bill. Ms. Burns, could you please provide a report?
Yes, so I gotta remember that. SB 425 would require hospitals, clinics, and other health facilities or peer review bodies to report allegations of patient sexual abuse or other sexual misconduct by healing arts professionals, including psychologists, to the board within 15 days of finding out about the allegations. Currently under state law, there is an 805 or Business and Professions Code Section 805 report that is required if a peer review body takes action against staff privileges. So if you have a psychologist working in a hospital, they have staff privileges from the peer review body. If that peer review body had allegations of misconduct, they investigate. And under the current 805 reporting, if they take adverse action against those staff privileges, or the member withdraws their application and just says, oh, you're investigating this, I'm just going to withdraw my application and leave, they have to notify the board. The board's enforcement program gets those 805 reports of misconduct and other issues after the fact, so after they have found something. And currently, that leaves some space in between when the allegations are brought up, some ways in which maybe the allegations never get brought to the board. Currently, for current 805 reports, we get a handful, I think it is, a year, so not a large amount. This would move that kind of reporting up. So 15 days after the allegations are made, they need to report it to us. So there could be a simultaneous investigation where the board could pursue investigation of the misconduct, the sexual misconduct, because that's what it's confined to. Simultaneously along with that peer review body. So it kind of takes out some of the loopholes that allowed some of the medical doctors at, I believe it's UCLA and USC, to stay kind of under the radar because no adverse action was taken against them, so they don't have to report just that they're investigating. They have to report after something has happened. This would bring it forward. The one thing I would point out, which is also in your analysis provided in the materials, is that this new 805.5 reporting also has an individual mandate, and that is different than your normal 805 reporting. So the 805 is the institution. That peer review body has to report it. This new 805.5 has the peer review body reporting it, or the facility, but it also has an individual mandate. So if that licensee or that healing arts licensee works in the hospital and they're made aware of the allegations, our reading also says that they would have to report as an individual. In speaking to Hill's office, that was kind of a whistleblower type protection, so that if the peer review body was not quite doing its due diligence, they would still get the report from the licensee. My understanding of the bill is that the fines in that bill are only related to the facility or the peer review body and not a fine on the individual licensee. So there's kind of a two-part there. Staff believes that the additional sexual misconduct reporting requirements, and mind you, these would be in health facilities and peer review bodies, so this would not be statewide. This would not be your private practice. It would be for those in those facilities and those locations. That this brings a warranted and long overdue reporting mechanism for misconduct in these facilities. So. And as a practical matter, board staff doesn't believe that we would suddenly see a spike of these either. It would be somewhat similar to the other 805 reporting. We would just get it earlier.
Thank you, Ms. Burns. And I just want to acknowledge that this was a good catch by our fabulous staff, because it was not necessarily in one of the codes that we normally check, and that it was due to the diligence of Ms. Burns and Mr. Glass-Beagle and staff that this bill was caught and put on our radar. So I want to make sure we acknowledge that. Is there board discussion about this complex issue that Ms. Burns just walked us through? Is there a motion to support staff's recommendation to support this bill?
So moved.
We have a motion by Dr. Harbsheets.
Second.
And a second by Dr. Horn. Is there public comment to this item? Not seeing any public comment. Additional board discussion? If not, could we please call the roll for this motion?
Sure. Tate?
Aye.
Harbsheets?
Aye.
Akwe-Badu?
Aye.
Phillips?
Aye.
Fu?
Aye.
Horn?
Aye.
Bernal?
Aye.
Motion passes.
Thank you. We're going to take an item out of order, being cognizant of some guests that we have in the audience. Related to item 22D, this is 425 out of 470 in your PDF packets, related to a proposal by the California Psychological Association with regard to registration categories for psychological testing technicians. And the reason why we're going to take this item right now is after the conclusion of this discussion, we will then go ahead and take a lunch break for that. So, and we just want to make sure we're not holding folks unnecessarily for that, and just being mindful of that. So we're going to go ahead and take this item up. So again, page 425 out of 470. The Legislative and Regulatory Affairs Committee heard this item on the 18th of March with a written update from the California Psychological Association. And as a part of the discussion, which we found very valuable, and there was a consensus amongst committee members related to the oversight of over these professionals, the committee did also want to see language before recommending a formal position to the full board. It's not the practice of the committee to recommend to the board taking a supportive action on a concept. Of course, we do, from the tenor of the conversation, it was very supportive, and we saw it as a very valuable conversation. Before I invite up public comment, I just want to ask if there were committee members with additional comments to this item.
I think that accurately summarizes our discussion.
Is there any board comment or discussion about this item? We'll come back to that, but I would like to invite public comment related to this. Oh, sorry, Ms. Burns, did you? Okay. I would like to invite public comment for this.
Hi, Elizabeth Winkleman again from the California Psychological Association. Thank you for taking this item now. Of course, I'll be staying the whole time, but for the other psychologists who are here, neuropsychologists, to speak to this issue. First of all, I wanted to thank the Legislative and Regulatory Affairs Committee for looking at this at their last meeting. We're sorry we were not able to have any CPA people from CPA in attendance because it was our annual lobby day, and I'd like to thank the board for considering this item now, and also the board staff for giving us some preliminary guidance on how to address this issue. So as summarized in my March 11th letter that's in your board materials, California CPA is developing legislation that would specifically allow the use of testing technicians to administer and score psychological and neuropsychological tests. And just to summarize the reasons for why we are pursuing this is, one is that this is a well-established standard of practice recognized in many states' laws, and it's also recognized by the National Academy of Neuropsychology, the American Academy of Clinical Neuropsychology, American Psychological Association's Division 40 of the Society for Clinical Neuropsychology, and by CMS, the Centers for Medicare and Medicaid Services. However, in California law, there is no specific reference to psychological or neuropsychological testing technicians, and psychological test administration is included within psychology's scope of practice, and there's no clear authorization currently for the use of testing technicians. And we also then, this was brought to our attention by our own CPA's Division 8 of Neuropsychology, that this is a problem in the area and that it would be very helpful, and I'm going to let some of our neuropsychologists speak to this more directly, how helpful it would be to have a clear regulation and permission to use the testing technicians. And initial meetings with legislative staff about this problem made it clear that we would need for this to be for us to be successfully promoting this such legislation to get the board's support. Regulating technicians, another reason is that, as I kind of alluded to, it would increase access to psychological and neuropsychological assessment services, and it would also provide greater consumer protections because the proposed legislation would involve registration with the Board of Psychology of these technicians. And it would the proposed legislation would specifically permit the technicians registered with the board to administer and score psychological and neuropsychological tests, but they would be under the direct supervision of licensed psychologists. So there would be no independent practice whatsoever by the psychological testing technicians. And based on standards currently in use around the country, we would anticipate that the bill would require a minimum of a bachelor's degree in psychology or a similar field, and training in ethics, test administration and scoring, plus a background check such as the fingerprinting that's currently used for other licensees and registrants under the Board of Psychology and other boards. And what we are asking for is we would like the board to discuss it and give us feedback, and if possible to give us support in principle for moving forward. I understand that you would not be able to take a official position, if I understand the process correctly, until we actually have a bill language introduced. But we'd like to get your feedback and, as I said, kind of support in principle. And I'd be glad to answer any questions people have about it, but I would also like to, I know we have several expert neuropsychologists here who would like to also make some comments.
I'm just curious at this point, have you found a sponsor for the bill that you're working with, or?
We're not there yet because we're really waiting to get some feedback from the board before we have the specific language. But there was interest in the legislature, but they really wanted to know where is this something that the board would be willing to have the registration and be supportive of.
So I know this is a pretty common practice. Pretty much everywhere as far as I know.
Yeah.
The thing I particularly like about what you're proposing is that there would be oversight by the board, that people would be registered with the board, and that does really help with public protection. I mean, so I think that's an extra added little piece, because I'm not sure that's the case in other places where this happens, but I think it's a really helpful piece for us.
Yeah, the model that we're looking at is the two other states that recently implemented these regulations are Connecticut and New York, and they're, I think, the only other ones that have some specific requirements, and I think only one even has the registration. So we would really be creating more of a structure and a consumer protection aspect to this than many other places where you're correct, they're just being used.
I have a question.
Mm-hmm.
Do you envision some type of exam that these people applying for registration would take as a part of the process to become registered?
Not necessarily. There's no other state currently requires that. There is an exam, but it's given by a private organization. And I don't know so that's not currently part of the proposal. It's something that we could consider if the board felt strongly about it, but I think there could be issues of, well, there's this one certification body, and it's not a one test, and but it's not required anywhere else.
Thanks. I was just curious.
Yeah.
Thank you.
It's a possibility. Thanks.
And maybe perhaps the neuropsychologist would be better able to address this next question, and if so, just let me know that, and we'll wait until they've had their presentation. But I am curious as to whether these test technicians work entirely under psychologists, or are they used by other occupational groups? I'm trying to figure out, does it fit squarely within the ambit of the Board of Psychology, or is it something that's more generalized and we're taking on something that doesn't involve psychologists?
Well, the proposal we have would purely be for psychological and neuropsychological testing, and it is really kind of it's a common practice within psychology, and it would just be intended to cover those people.
That's very helpful, thank you.
Could we invite additional public comment, since there are no additional questions from the board at this time, and I understand there might be other folks as well here.
Yes, thank you very much.
Good morning. I appreciate the opportunity to speak before you. And my name is William McMullen. I'm a board-certified neuropsychologist through the American Board of Professional Psychology. I practice up in San Francisco. I trained at UCLA as a postdoc. I did my pre-doctoral internship at Cleveland VA and graduated from Wayne State in Detroit, and have practiced neuropsychology throughout my career. And when thinking about this, I think one of the things that might be helpful to understand is what it is that we do for anybody who's not really familiar with neuropsychology, and what the process is and why we do what we do. And then why would a testing technician be helpful? So we see patients who have known or suspected brain injury or brain disorders and apply the tools of psychology assessment to those cases. We're assessing memory, language, attention, those kind of things. The patients are referred typically by neurologists and neurosurgeons, psychiatrists, and some general practitioners, and the findings are helpful to them in working up the patients for various things like surgery for epilepsy or deep brain stimulation for Parkinson's, those kind of things, where the neuropsychological assessment component is part of the workup to make sure the patient gets the most appropriate treatment. Currently, what I do involves an interview with the patient and then administration of neuropsychological and psychological tests that can take anywhere between 2 hours for a very short case up to 6 hours or more for a longer case. Test scoring, interpretation, report writing, and ultimately providing feedback. So they're very time intensive. And when I was a graduate student in Michigan, I worked as a psychology technician in a private practice, and I was trained in some of the tests by a psychology technician at Rehab Institute of Michigan who had a psychology technician on staff. And I can say that the ability to administer these tests is not something that requires a doctoral level. The tests are designed to be reliable, and as long as somebody is trained in the administration and they're a competent person, the test should be able to be administered. And when I was administering tests as a psychology technician, I did, I think, just as good a job of doing that as I do now as a neuropsychologist. I don't think there's much different. And that's why I think a lot of our organizations have recognized this. If you were to go to Cleveland Clinic, for example, to get a neuropsychological assessment, you'd see the psychologist for interview, you'd see and the psychologist would write the report, but you would not see the psychologist for any of the testing. That's all done by technicians at Cleveland Clinic. And the same thing goes for Case Western Reserve and some others. When I was at the Cleveland VA, I was able to make use of a psychology testing technician, and it greatly increases the efficiency with which you can work with patients. And so you can see more patients more quickly. And not only is the testing technician doubling your work, it's more exponential than that. While they're doing testing, you can be dictating reports and interpreting reports of people you've already gotten results from. And so you can see many more patients than you can see currently. Right now I have a 3 to 4 month waiting list to get people through, and that's not at all uncommon. And with a testing technician, you can shorten that up. You can also increase the turnaround time for the test results to be produced. So it just makes it much more efficient. The way we currently do it is as if, if you were to go to an MRI and the radiologist would accompany you to the MRI, put you in the scanner, operate the scanner, produce the films, and then do the interpretation and report. It's not the most efficient way to do it because it's been proven that the administration of these tests can reliably be done by non-doctoral level personnel. And that's why I think in most of the country it's something that's utilized to help with that. I think if you were to regulate and allow the use of technicians in the state, or at least clarify that they can be used and clarify how they're trained, I think that would provide a lot of benefit for patients in terms of being able to have more access to services. It would speed up turnaround time of reports, and it wouldn't lose quality. You'd maintain the same level of quality. And the psychologist, as far as I understand from CPA, would still be responsible for the work of the technician, as is true in other states. And so they need to be able to make sure that the technician is properly administering the test. But that's something that's been proven to be done in other states. And indeed, the new Medicare CPT codes recognizes psychology technicians. It also appears to value the report writing time at a higher level with regard to insurance than the testing time, which sort of is suggesting that they're in favor of pushing more use of technicians because it also tends to lower cost. The cost of using a technician, a hospital couldn't bill as much for a technician's time as they can for a psychologist. So I think that's basically my presentation.
Thank you. Ms. Bernal?
I just have a quick question. Why is this, just out of curiosity, coming up now as opposed to it not being, years ago, or I don't know when New York adopted this or things? I'm just curious.
That's a really good question. When I was working in Michigan, Ohio, and New York, and in New York, I think they did have people working as technicians years ago, and then for a time they weren't, and now it's been authorized and more regulated. And then I moved out to California in 1997, and I have been hoping for the longest time that California would clarify this because I think I'm not the only one. I think there's a lot of neuropsychologists that would love to have had this brought up 10 or 15 years ago. It just slows everything down and makes it harder to get more patients through. And you can imagine, like in San Francisco, it's very difficult to get practitioners to move there because of the cost of living. If you could hire testing technicians, you could see more people. The whole problem is exacerbated even more because of the cost of living issues.
Is there additional public comment?
Sorry, go ahead.
Well, I just wanted to add to what Dr. McMullen was saying about this is I think one of the reasons why it's come to the forefront recently, I think there's been a lack of clarity for a long time, and some people use them, some don't, but also because the psychological and neuropsychological testing codes that are used by Medicare and Medicaid and others as well, but promulgated by the AMA, were recently revised for testing. So there's been a lot more attention to the testing codes, which include codes to bill technician services for administration and scoring of tests. And as Dr. McMullen mentioned, kind of favors the use of the technician. So that just happened in beginning of 2019.
Dr. Tate?
Thank you for your presentation, Doctor. I do a lot of testing myself, so I'm very empathic on the 2 to 5 hour testing sessions. I completely understand. I have a question, and I'm thinking it out. So in those appointments, I rely a lot on what the patient is doing and what I'm watching. It's actually very useful. When you have a technician and you don't meet with the patient, how do you get that knowledge to you? Are they tape sessions? Does the technician, are they trained in watching body agitation, things like that? How would you incorporate that into the report?
So I can explain how it's done when I've used technicians or when I was a technician. First of all, I wouldn't advocate that the psychologist not meet with the patient. I would suggest the psychologist needs to be responsible for doing an interview, which for me, an interview usually lasts at least an hour. And so there are a lot of behavioral observations you're going to make during that interview session. And then there is some training that needs to go on with the psychology technician to alert them to the kind of things that you need to pay attention to while you're testing. I would, when I was doing this, I would fill out a behavioral observations form that was already prepared, but I also was trained in how to observe behavior. And then the testing technician is, at least when I have done this and when I used one at the VA, is in the same place as the psychologist. So if something comes up that the psychologist needs to see, or a break could be taken and the testing technician can get the psychologist to observe what they're observing. So for example, when I see patients with epilepsy, it's not that uncommon that they'll have a seizure in front of me. Now, most of the time, that actually happens during the interview because that's a pretty long interview and there's plenty of opportunity for them to have a seizure in that time. But sometimes it happens during testing. So if I was to be using a testing technician while seeing a patient like that, they would need to be trained to know what to look for when somebody starts to have a seizure, what to do when they have a seizure, like any of our other staff would have to do. You know, the medical assistants and the nurses and all of those in the epilepsy clinic need to know that. And so that would be the responsibility of the psychologist to provide the training necessary to do those kind of observations.
Thank you for clarifying.
Mm-hmm. Sure.
Is there additional public comment on this item?
Yes.
Can I get a sense of how many additional persons would like to speak? Two persons? Right.
Good afternoon. Thank you to the board. My name is Diane Shiner. Excuse me. And I'll keep my comments very brief. I am an early career clinical psychologist licensed in California in process of becoming a neuropsychologist through the boarding process. And in addition to the comments that my colleague made regarding sort of the economics and access to care in a timely manner, just from the position of the perspective of an early career psychologist, I wanted to also mention why somebody like myself would be in support of using technicians to assist in the care that we give to our patients. As we're growing our practices, it makes sense to be able to clarify or be able to expand our practices further into the area of intervention, for example, cognitive rehabilitation, things that I have ample training and interest in doing. But as a neuropsychologist, much of our time is spent right now in the work of the actual data collection. So to be able to work with appropriately trained and regulated technicians would be something that would be not just a very beneficial to us who are trying to expand the reach of neuropsychology into the interventional services that psychologists also offer our patients. And then just from an educational pipeline sort of training perspective, I think back to my training right after my bachelor's in psychology, I joined a research lab, and this is where I really got my training in neuropsychological assessment as a research assistant, effectively a technician collecting data for studies. And this really guided how I went on to choose to pursue a PhD in clinical psychology and ultimately with a neuropsychology focus. Right now, as I work as a supervisor for doctoral level students who work with me in their clinical training, many of them don't have the training background that I had as a research assistant doing that technician aspect. The idea that we'd be able to create more opportunities for students or early career individuals who may be interested in further pursuing a career in psychology and neuropsychology by expanding just our footprint in the healthcare arena is something of interest, or I think should be of interest to us as a field as well. And so perhaps it's a little aspirational, but being able to create this type of position that's akin to other types of entry point positions for those in other medical fields, I think would be a good thing for psychology in general. So that's all I had to say. Thank you very much.
Thank you. Additional public comment?
Hello, I'm Bob Tomaszewski. I'm also a neuropsychologist, and thank you for the opportunity to speak with you today. My perspective is I'm in private practice in an outpatient setting. I've been on the board of California Psych Association Neuropsychology Division, and we really developed this impetus to resolve this issue, to try to clarify this issue over the last year. And so we're still on a task force and working with CPA, and really appreciate their support and what they're doing to help guide this process. And certainly welcome your input in terms of guiding the process as well to clarify it. I think the major issue I see from a clinical perspective is quality of care. Dr. McMullen mentioned it may take him 3 months to get an evaluation for somebody that may be needing those results for surgery, for an implant, to change their clinical condition that they're living with and the burden of that. So the referrals I get are typically delayed about 3 months as well. And I work with brain injury recovery, basically, individuals recovering from traumatic events. And again, delaying the evaluation for 3 months, which is the current standard out there because of the time involved in preparing these reports, collecting the data, scoring the data, it affects the clinical utility. So the overall clinical usefulness of the information, if a neurologist refers to me and has a question about their patient, 3 months later, 4 months later, getting a report is minimizing our effectiveness in providing quality of service. So I think overall it'll improve services for the consumers, services for the patients. It'll be more cost effective as well in terms of being able to provide it without the psychologists themselves having to administer all of the tests. We still may do a portion of the testing. If the technician sees something that's interesting, I may go in and administer a portion of the test or observe directly those portions of the test to further understand what's happening behaviorally. But nevertheless, it will be great time savings, and I think also fit with the new Medicare mandates about billing for technicians and having that available to you, so it also increases cost effectiveness of services. So overall, I see it as a real step forward if we could clarify this for the state. I've been practicing here for 30 years and over 30 years, and it's been an ambiguous issue for the entire time. So I think this would be a method of going forward, and with CPA's support, being able to structure it and regulate and make sure that the individuals have the supervision and the specialized training that they need and the oversight.
Thank you. All right, oh, yes, we have a third person, please.
Dr. Melody Schaefer, CPA Division 2. Just from my personal experience in my clinic, I'd say this turned off. Over the last 10 years, we're seeing more and more patients come in that are elderly, that are needing to be evaluated for cognitive deficits. And I assume that as the population keeps aging upwards, that we will see more of this. What we're seeing is, even with primary care physicians, many times they can't get an order for an MRI to rule out what might be going on cognitively in terms of a dementia type process until there's neuropsych testing done or some kind of neuropsych evaluation. In our area, which is replete with psychologists, but few neuropsychologists, we're seeing the same thing that was reiterated here. There is a backup, there is not opportunities for testing in a timely manner. So I would support this as well. And like one of our speakers about circa 1980, I did this as a technician before I had my doctorate at the VA, and I had training on how to administer what back then was called the Halstead-Reitan, and it went swimmingly. It was a great foray into moving forward in my career plans, and I didn't see any problem with it because we had a psychologist present, gave adequate supervision, and made a lot of other things possible. So thank you.
Thank you. Is there additional board comment or question, Dr. Horn?
This is a little off, but I mean, I'm totally supportive of it, and I've said that. I think it's really a good idea, and it's a long time coming. And I'm remembering not too long ago, and I think it was the assessments for, like it was qualified medical examiners or something like that, was it? That they took, that neuropsych wasn't allowed by our previous, I think it was the previous administration, delaying assessments and stuff. Yeah, that's right, it was workers' compensation. So, I mean, just anything that helps in this regard, I think is really a good idea. I'm glad y'all are pursuing it, so.
I always think it's important to consider questions of access of care as it relates to consumers, and it sounds like this would greatly improve access to care. And just as people with a bachelor's and the appropriate training may be well qualified to do the actual administration of tests, which can, after you've done them 40 or 50 times, can become pretty monotonous. Even though it's fascinating on one level, on another level, you've done it, been there, done that. And honestly, I don't think some of the tests really require a doctorate to administer them. A great deal of them, particularly with the computerized tests that they have now. So I'm very supportive of the idea from the idea of access to care. Our primary charge here is the protection of consumers. So I say this in a personal capacity because I don't think the board is necessarily going to be able to take a position today, but we do want to indicate, or I want to indicate, my receptivity to this idea, and that I think from a consumer protection point of view, since some people I assume are already using technicians without any formal sanction, I'd much prefer that they'd be registered, fingerprinted, and appropriately screened so that we make sure to best protect consumers in situations where perhaps the neuropsychologist made a bad choice in terms of their testing technicians. So I'm very intrigued and supportive of the idea. And hopefully once we have legislation, we'll be able to take a more formal position on it. And in the interim, I'm sure you can, as you have language even before the board's going to meet again, you can obviously bring it to legislation, what's it called?
Legislative Legislative and Regulatory Affairs
Yeah,
Committee. Dr.
that
Winkleman got
one.
it on the first try, too.
LRA is all I can think of. LRA. I'll be a new pseudonym. So I personally am positive about this development and think it would be a good thing. And obviously it impacts, from a psychologist's point of view, it impacts their ability to do the job in a way that can get effectively reimbursed by payer sources. And that's certainly a wonderful consideration for psychologists to have relative to this whole thing.
Is there additional board comment on this item? So, Dr. Harpshoots?
I was just going to echo that, again, I am happy to see this come forth at this time. Wish it had come forth before, and thank you very much to CPA and for supporting the Division of Neuropsych, and I'm in support. Thank you.
Ms. Sorek?
Really quickly, I just wanted to mention that we have, staff has been helping CPA with some kind of technical guidance on some of the intricacies of presenting a Sunrise application to the Business and Professions Committee. And even though the board may not be ready or able to take a formal position, that staff is willing to continue to provide any kind of technical assistance that the association would require throughout the process. So I just wanted to put that out there.
Thank you, and thank you, to our staff for providing that technical assistance. That's really helpful for us. Yes, Mr.
Just wanted
Quavido?
to add, in addition, on an even more practical level, it adds another rung to the employment opportunities for. So, thank you all.
So this is an informational item for today only, and so we'll go ahead and continue to watch and eagerly look forward to language that will be presented or introduced at some point. And staff is continuing to provide technical assistance on questions related to a Sunrise application. So, Dr. Winkleman, it seems like you have a comment, so before I continue.
No, all I wanted to say was that how much we appreciate the board considering this item and your feedback, and also the board staff's willingness to continue to help us with the technical issues. So I just wanted to, before we move off the item, express my gratitude for that. Thanks very much.
Thank you. So if there's no other board comment, we will actually, I'll turn it back to Dr. Phillips for our next item, or for our next announcement.
Hello there. So we are now going to take a 40-minute lunch break? We'll take a 45-minute lunch break. So we'll return here by my watch. That would put us at about 35 minutes after the hour to conclude our discussion of the remainder of the agenda. Okay, the meeting's now back in session. I'll do my professor stare. Then we'll turn the meeting back over to the chair of our Legislative and Regulatory Affairs Committee. I'm not going to remember it next week, so don't.
So we are now returning to, I was going to say resuming the normal portion of the show, but we've been all around. So we are now on item 22C, 2A, which is page 204 out of 470 on your combined packets. This is related to Assembly Bill 8 by Assemblymember Chu. The bill will require on or before December 31st, 2022, that each school of a school district, county office of education, or charter school have at least one mental health professional. The committee, when we heard this bill, wanted the board to discuss Section 2 of the bill related to determine if the provisions requiring a licensed psychologist be under the supervision of an individual who holds a services credential, quote unquote, merits sending the author a letter of concern that requiring a doctoral level licensed psychologist to work under the supervision of a services credential individual is unnecessary and burdensome. So I'm going to first turn it over to Ms. Burns to provide a little bit more information on the bill, and then I'm going to then turn it over to our chair of licensing committee, Dr. Horn, who may have some comments on it. So Ms. Burns. Oh, just hold on. This is Assembly Bill 8, Chew. 204. Sorry.
22C2A.
So this is item 22C2A, Assembly Bill 8 by Assembly Member Chew. In your combined packets, it is 204. And Ms. Burns.
The only update really needing to be provided is that on April 24th, it passed out of the Assembly Health Committee. So it is now out of its Policy Committee and can head on to the Fiscal Appropriations Committee. This bill, it's mostly brought to you to see if we should be writing a letter of concern about those provisions of being supervised as a doctorally licensed individual by someone with a services credential. Obviously, the letter of concern would explain why that might be burdensome and unnecessary, and then if it's to address anything else, licensing might need to bring up.
Ms. Burns, I read too quickly and hastily, and so could you walk us through the bill a little bit more? I apologize, I was moving too quickly, and so walk us through the bill, please.
No problem. So this bill would require each school or school district or county office of education or charter school to have at least one mental health professional for every 400 students or pupils on campus. In this bill, it would define broadly mental health professionals, and it would include psychologists, of course. However, it does have a subsection. It has Education Code 49429.5, Subdivision C, and it would require a licensed psychologist to be under the supervision of an individual who holds a services credential. So that's not currently something normal for those. To my knowledge, most schools are not hiring psychologists as compared to school psychologists, but it was worth bringing up to you as this is something that seemed kind of odd to us. We brought it to policy and advocacy, and you guys said we should maybe bring it to the board for consideration for a letter of concern.
Thank you. And I misspoke. Dr. Horns will opine on another bill at a later point. Dr. Phillips.
Well, and just to capture some of the discussion that we had in the licensing, LRA. The concern here is that we've got somebody that basically has got some kind of certificate and maybe a BA degree that's going to be supervising the work of a psychologist, which seems problematic to me.
I'm sorry, you said supervising the work of a psychologist?
Yes.
So I was just reading it, trying to see where it says it. And if I'm looking at page 207, C, and I just want to make sure I'm reading this right. This says a mental health professional who does not hold a services credential, with a specialization. So that person would be supervised. Okay, so there's, okay.
They need
gotcha.
They need this credential.
All right, they need that credential. Yeah. Okay.
So obviously kind of a technical thing, but it was worth bringing to your guys' attention, so.
I think it would be appropriate for us to write a letter of concern in that this speaks to the scope of the license that we regulate. So I don't know if anybody else feels similarly.
I agree, but the question I have is what would keep us from opposing it?
I would say that it,
Or unless amended or something like that.
I'm going to suggest it's not as much of a consumer protection aspect, so that it would be somewhat odd to oppose it for that provision as compared to talking to the author about making technical amendments or clarifying amendments as the Board of Psychology, obviously. Your professional association may take a different direction.
Dr. Horn?
That makes sense, what you're saying. So I agree. Did you say that, Stephen, to write a letter of concern about this? I think we should do that. I think we should talk about what psychologists are allowed to do by the Practice Act or whatever, and just that would be inappropriate.
Do I hear? Go ahead, Dr. Habshi.
I was going to say, as I read it, they are including in mental health professional a marriage and family intern, for example, and to look at psychologists and interns. I mean, I think they need some clarification that we might suggest.
So what I'm hearing from the discussion is there's an interest, at least from some of the members, to write a letter of concern to the author. It would be related to the provisions here, and it would be technical in nature. Is that a motion on the floor, or do we need additional discussion?
I'd be happy to make the motion.
Dr. Tate is making the motion. Is there a second?
Second.
Dr. Harbsheet seconds. Is there public comment related to this item? Please step forward.
Melody Schaefer, CPA Division 2. I think there may be a consumer issue possibly at play. If you have someone that is non-licensed as a mental health professional supervising and possibly directing psychological care, that doesn't seem therapeutically prudent. So I'm wondering what the board might think of that as a point of concern.
Thank you.
Oh, and also, sorry, point 2. If the verbiage, as you pointed out, references MFT interns, I find it questionable why they wouldn't include psychology predoctoral interns as well, since we have more education and training.
It appears for some reason when we get a lot of statutes, there's references to marriage and family therapy interns and trainees. Oftentimes there's not a similar provision for psychological assistants and for psychological interns and trainees.
If I may share with you my perception of what might be contributing to that. The Mental Health Services Act, MHSA, and their division within the state of California has meetings to discuss workforce education and training and disbursement of the money for MHSA, which we know comes from the millionaire's tax. And in having put myself in the running to be on the board a long time ago because I thought it'd be replete with psychologists, it wasn't. I was the only one there. And the head of the social work organization for the state was there with other social workers, same for the MFTs and CAMPT. And it seems like we don't always get invited to the table or find out about these things except ex post facto. I'm not saying that this is what happened in this case, but I know that MHSA put out another calling for involvement and more planning for hiring and training of people within the system of mental health statewide. And I only found out through KPIC because I'm still connected to them where they send me things, yet I don't think it gets distributed to everyone. So that might be a factor that's influencing why we don't kind of have our voice at the table. And I'm not sure, Joe may have heard about it, I'm not sure.
Is there additional public comment?
Dr. Joe Lindercrow with the California Psychological Association. Just to let you know, we have this bill under review at this time, and our board will be discussing it at their May Board of Directors meeting. But both from the intern perspective and also the supervision perspective, we were sort of waiting to see if the bill was going to be amended in some way. But we have it under review. We will be making a decision probably in the next few weeks about a position on the bill, just FYI.
Thank you. It's additional public comment or board discussion. So one thing I would keep in mind about the bill, just having a big picture perspective, is that it is requiring school districts or county office of education to have a mental health professional per every 400 pupil. And so I think setting a message of opposition in the big picture, when we have a very narrow concern area and interest, it's a balancing act. And I'm not necessarily from my individual perspective, so inclined to give an inclination that we're opposed to having mental health professionals in a school setting. That is not the motion on the table. The motion on the table, however, is a letter of concern to address those specific issues. And unless I hear an amendment to that motion and additional board discussion, I'm going to call the roll. Is there additional discussion? Dr. Harpsheets?
No.
Oh, okay.
Ready?
Please do.
Tate?
Aye.
Harpsheets?
Aye.
Akwe-Badu? Phillips?
Aye.
Fu?
Aye.
Horn?
Aye.
Bernal?
Aye.
Motion passes.
Thank you. Next item on the agenda, item 22C 2B, as in Barry, or boy. And this is page 210 in your combined packet, Senate Bill 163 by Senator Portantino. This is related to healthcare coverage. Ms. Burns, could you walk us through the bill?
So SB 163 would revise the definition of behavioral health treatment to require the services and treatment programs provided to be based on behavioral, developmental, behavior-based, or other evidence-based models. The bill would also remove the exception for healthcare service plans and health insurance policies in the Medi-Cal program consistent with the Mental Health Parity and Addiction Equality or Equity Act of 2008. For the board's purposes, staff looked at the bill because we had concerns about the provisions allowing psychological assistants and registered psychologists who have obtained 500 hours of training in designing or implementing behavioral health treatments to supervise qualified autism service paraprofessionals. Board staff was unaware of the prevalence of this happening in the field, so we brought it to the Policy and Advocacy Committee, and there were some concerns by board staff, including licensing staff, of exactly how we would treat this, how supervision and hours would be concerned, whether or not the board would need in any way to monitor this 500 hours of training, and essentially the nuts and bolts of this allowance being made in statute would also beg questions of what qualifies as their SPE versus other things. And so in our analysis, which is on page 215 of the combined packet, it has some programmatic questions that we've posed that we wanted to highlight for the board, whether or not the 500 hours of training required to supervise under the bill would count towards the SPE, what would be the supervisory requirements if that PSB is supervising, how frequent do they need to meet with their qualified autism service providers. So these are some of the questions we posed to maybe have the board think about as well. Not so much in the needing to take a position, but in the concerns that we would have with if the bill were to chapter, how does implementation look? Because obviously, we would be the first line to get the questions of, oh, now I can do this, it's official, and then does it count, how does it count, what counts, and those kind of questions. And obviously liability, and also who's the ultimate person responsible. Because often the top of that food chain ends up being a psychologist or psychiatrist or the other top-level provider, the BCBA certified person that's writing these plans, but the people underneath them implementing these treatments, they're all part of this chain, and if the PSB is now in between different levels, how does that work out? So,
please opine.
So, kind of how I read it, and y'all correct me if I'm wrong, but in graduate training, it's not uncommon at all for people in advanced stages of their training to supervise people at earlier levels of training. And so I see a psych assistant and a registered psychologist as two of those people. They're advanced in their training. And part of what they learn from that is how to supervise people and all like that. But they're being supervised for what they do. And if they are psych assistants, they are supervised. Now, I don't know about registered psychologists at this point in time, if they're supervised, but they are they supervised? Okay. So we've got two groups that are being supervised. So to my thinking, their supervisors would be ultimately responsible for what they do. And really the 500 hours are learning a technique or techniques. It's not learning anything, I don't want to say anything major because, I mean, those same techniques they'll be supervising people who may be doing some of those same techniques, you know, learning how to do those techniques, but have even lower levels of training. So I think their training, and to my reading, would allow them to pick up those techniques if they haven't been taught that already in their graduate training. And the supervision of somebody under them while they're being supervised also helps them be supervised in a competency, which is supervision, you know, and that's one of the competencies that we expect or think that licensees should have or can have. So that's kind of my reading. I'm not really worried about it at this point, is how I understand it. So.
Mm-hmm. My reading of it is that they're creating a category of activity that a psych assistant or a registered psychologist might be involved in, where they are going to be supervised by someone who is not necessarily a psychologist. They're a qualified, whatever they are, I forget what the exact title for it is, but they're autism service professionals. So I think it's going to create confusion, and confusion in the following respect. If they're operating within their capacity as a psychological assistant or within their capacity as a registered psychologist, in order for them to count those hours, they need to be getting direct supervision from a psychologist, not a qualified autism professional.
Oh, so I wasn't reading that. I see that they're authorized to supervise.
Could I?
Their authorization
maybe
to
I've got it
supervise.
confused.
It seems to me that, the way I'm reading it, they have to have already had the 500 hours before they get there, right? Mm-hmm. And then they would be doing the supervision, but they couldn't count those hours unless they were supervised by a psychologist, right? That's what you're saying?
Well, yeah, my concern was that they were going to think that they were accumulating hours, and this, or that this bill would provide a back door for people to get hours where they're not actually being supervised by a psychologist. Now, that may be reading too much into it.
Yeah, I didn't see that.
I think that we should ask for clarification. Personally, think we should ask for clarification in the statute that if they're operating in either of these capacities, they need direct supervision from a psychologist.
And I would say under current law, the top level provider can be a psychologist, or it could also just be the BCBA certified individual. So it doesn't always have to be a licensed psychologist. And that could be where the confusion lies. They could be employed by that person, but if they are not supervised by a licensed psychologist or psychiatrist, you can't count the hours towards your supervised professional experience for the purposes of licensure. So I think that's where there could be confusion if there isn't clarification. I mean, it sounds like this is already happening in the field to some extent. I just don't know that it's happening and allowed to be counted as your supervision hours unless, of course, you have that supervisor that's a psychologist.
Well, I have another question. Even though, let's say, a psych assistant is doing this, what if they are doing this for pay, that they're making money on the side, they're not necessarily counting hours, but now they apply for licensure and they're asked that question, I can't remember how it was worded, that basically they have to certify that they haven't worked in a psychological capacity while being unlicensed. Even though, could this, if they had this as a job on the side, could this be a problem with answering that, no, I haven't worked in a psychological capacity?
I think we should bring up Ms. Chung from licensing to answer some of these questions. Yeah.
Hello. Okay, so I want to wheel back us with a little bit of current information. So for a psych assistant, in any capacity, in order for them to perform any psychological functions, they would need to have a qualified supervisor to supervise them in order for them to do any of these things. Mm-hmm. And the two types of qualified primary supervisors are licensed psychologists that are licensed by the board or the board certified psychiatrists. Without any of these two types of supervisors associated with their registrations, they cannot practice or cannot perform any psychological function. So this is a point of clarification. So that might be, could be a base.
So here they have this QASP supervisor, let's say, who, excuse me, is not a psychologist, but has this certification to do that. And they're not planning to count hours, but they're doing this as a part-time job to supplement their income. I guess my question would be, could they then answer that question on the application for licensure saying that they haven't? This has come up in the crisis house thing, and I'm wondering if this is similar in any way.
But what this seems like to me, and I might be wrong, so I'm looking at you, Ms. Chen. If you're performing this service, which is supervising QASPs as a psych assistant or a registered psychologist, if you are a psych assistant or a registered psychologist, you're not doing it outside of that title. So you're being supervised, right?
Well, but what I'm saying is if the QASP who supervises that psych assistant
I'm not seeing the QA. I don't see that part in here. That's what I'm asking.
Can you clarify whether that's what the statute says or not?
Here's my clarity as I understand it, is that they could be performing these functions through that external BAC, am I saying it wrong, BACB? The other certification, so they would be operating under those provisions instead of our provisions. So
but then they wouldn't be called a psych assistant,
and that's
they
where
wouldn't be called a registered psychologist. So if we're calling them that means they're doing it under our auspices.
And therefore they fall under all of our provisions.
That's right.
So it would seem to me that there actually should not be a reference in here to psychological assistants or to registered psychologists, because they won't be, under this structure, wouldn't be operating within the context of their psychological assistantship.
But why wouldn't they? I don't see why they wouldn't. I'm not seeing in here where they're being supervised by somebody else. What I'm seeing in here is that
they could be.
They are supervising. So I might be looking wrong.
You very well could have a situation where the qualified or the autism service provider, the top tier level, is a psychologist, and therefore anyone working underneath them, a PSB included, would be operating within our system, but could be working with autism service and providing those supervision. So there is the area where they could be doing this, and it could be part of their hours already.
But they could also, under the statute, be supervised by a BACB who is not a psychologist or a psychiatrist.
So where does it say that is partly what I'm asking.
Well, that's why I was asking for clarification
Okay.
from Ms. Burns.
I want to apologize that your packet has the wrong language for this bill. Let's see. Am I wrong? Where did it go? It does. Yes, apologies, that is the wrong bill text. Correct analysis, correct memo, wrong bill text. Yeah, we'll send you all the link. Yep. Let me pull it up. It's all within the broader context of these can have two different paths. So this could be a licensee as the top tier provider who's supervising the PSB, who's supervising the behavioral health treatment, or the QASP, the lowest level paraprofessional, but it could also be where it's external. So I think that's why we thought clarification might be warranted.
Because, I mean, obviously none of us have a problem with a situation in which the BACB is also a psychologist or psychiatrist, and they're getting the appropriate supervision.
Where does it say this in here, or does it?
It says it in the general provisions that rule this in the health and safety code.
And I believe staff is sending out a link to the bill text that's going to be available online so that we have the correct language in front of us. And my understanding is that the section of concern, once that text goes out to us, would be Roman numeral 3. Under
here we go.
Item 2. So the link just got sent.
Yep.
To your DCA emails.
Oh, let me get there.
Yeah, we'll take a pause real quick.
So let's see.
Okay.
So once you get the link, you're going to go down to Section 1, and you're going to go to Section C. Oh, these are a lot of numbers. C4D3, which is, sorry, that was going to get awkward. So the provider level means a person certified by a national entity such as a behavior analyst certification board with a certification that is accredited by the National Commission for Certifying Agencies or the American National Standards Institute, and who designs, supervises, or provides treatment for pervasive developmental disorder or autism, provided the services are within the experience and competence of the person who is nationally certified. It can also be a physician, surgeon, physical therapist, occupational therapist, psychologist, marriage and family therapist, educational psychologist, clinical social worker, professional clinical counselor, speech language pathologist, or audiologist, who also designs these. So that could be a variety of people at that top level providing the supervision. If it's a PSB operating under their registration, they would need to be operating under the supervision of a licensed psychologist or psychiatrist.
Right.
So I don't know that it's problematic that this law says they can supervise, it sounds like, for you guys. It's more that we might want to have clarification in there that they still need to operate under their supervision requirements in the code.
And I think that's probably the cleanest way to do it.
Yeah, I do too.
That psychological assistants and registered psychologists are still subject to the Psychology Licensing Act and supervision requirements contained in it. Because otherwise you could have a supervisor under this scheme and people might think they're getting 500 hours of supervised professional experience when they're not, because they're being supervised by, this law would allow them to be supervised by a variety of different licenses or credentials.
Well, current law allows them to operate under those supervisors all,
But not
as their SPE.
Not in their capacity as a psychological assistant.
Exactly.
Yeah.
So that would need to be clarified.
And
Is that what you're saying?
Yeah, and I will add, there are a lot of early graduate students and people that are thinking about going to graduate school in clinical psychology. This is how they first got introduced to the field, is working within an autism service provision organization, which I think is fantastic experience. We wouldn't want to discourage that. We just want to make sure it's clear what happens with psychological assistants and registered psychologists.
So, quick question on, I'm looking at the PDF version of the bill because I can reference line numbers. So this is going to be under, backtrack it, under D, Roman numeral, lowercase 2, big capital Roman letter 3. This is page 7, line 16 through 23 in the PDF version. So based on the,
we don't have that.
So based on the link that was sent to you by staff members, if you go to the top of the link, you can click PDF. It might be helpful. It's easier to reference line numbers than.
That's a good idea. Yep.
So Ms. Sorick is providing assistance to get you to the PDF copy so that we can use line numbers, which might be a little bit easier.
Mine doesn't have line numbers either.
Once you scroll down past the summary, it'll have line numbers normally.
Okay.
Legislative,
there we go.
Yeah, Leg Council's digest summary won't have a line number.
So you said page 7?
Yes. Before we go, does everyone have the PDF on their computer before I move forward? All right. So it's page 7 of the bill, line 16. And it does say the person is a registered psychological assistant or registered psychologist pursuant to Chapter 6.6, commencing with Section 2900 of Division 2. So it does reference our code there. Does that address the concern of making sure that's within our practice or not enough?
That's not.
Not enough.
It was not speaking to.
Okay.
I just think it's worth putting in there that the supervision requirements
remain
the same. Something even that simple, that pursuant to the supervision requirements for the position or registration. Something very simple, technical amendment at best.
And it can eliminate a lot of questions that people might otherwise have that are trying to operate in this capacity. And it also gives you a specific provision to tell them to look at if they're asking if I'm getting supervised professional experience for it or not.
I have one more question.
Again, I want to say, if they are serving as a psych assistant or a registered psychologist.
They can supervise.
Huh?
They can supervise.
Yeah, but what I'm saying is they have to be complying with our regulations and laws. That's just what I'm saying. So
Okay. And I guess to follow up a thought that you had earlier, we don't want to discourage situations in which registered psychologists and psychological assistants are given the opportunity to supervise other types of behavioral health workers.
Right.
That would be valuable experience for them once they get into their careers. So we want to strike that balance, I think.
Dr. Harpsheets?
So I agree with all that, but I just have a question. In that, starting with line 16, they have to have obtained at least 500 hours prior to doing this. So would they do that through some educational program that's already, I saw earlier, some time was specified? it said there was some question in the author's note in the previous version, wondering if this 30 hours of training or something was too low. But nevertheless, they would have to have come in with that training already, correct? Is my understanding correctly?
Before they can supervise.
Before they can
Yeah,
do
they
this,
have to have, and I'm assuming it's specific training in ABA or,
Yeah, and that's something.
Behavioral.
Right.
And probably part of it is actual supervised work with the population
Right.
where they're implementing the interventions.
Probably.
Okay, thank you.
Additional comments by board members? So what I'm hearing is that there is a desire for a technical amendment to clarify that psychological assistants and registered psychologists would still have to be under our Practice Act. That's the clarifying amendment, I think, is where we're landing. Is that the case? So my question then, I guess, is to Ms. Marks or Ms. Burns, is do you need a motion then to direct staff to offer these amendments, technical amendments to the author's office, or what is the preferred path forward given where we're landing?
That would be where you want to go with how far you want to push. Do you want to submit the letter of concern, talking about there's a need for technical clarification? Do you want to support if amended, even though we haven't really taken a look at all the rest of the provisions of the bill and how that would impact? So that would be my thought, is more of another kind of a letter to the author with these technical concerns, which could very well get you the quick technical amendment we'd like for clarity purposes.
How do folks feel about a letter of concern?
It's really, let's just clarify this, you know, if they are working under these titles, then they are subject to our, you know, board regulations, basically.
Dr.
Because
Harp?
that's how they're serving in that capacity.
Dr. Harpsheets?
I saw in the bill analysis that staff is asking us this question. One of the questions was, would the 500 hours of training required to supervise an SB 163 count toward a registrant's supervised professional experience requirements for the purposes of licensure as a psychologist? So, does that answer that question, Ms. Burns?
I think that's a technical nuts and bolts ones after that, but it sounds like we wouldn't, right? Or you wouldn't. So, yeah, so then it would not count. So then the 500 hours would not count then.
So if folks seem to be comfortable moving forward with the letter of concern, can I have a motion to have direct staff to draft a letter of concern to provide technical amendments clarifying that the psychological assistants and registered psychologists would be practicing under our act?
Can I suggest that it's not a letter of concern, but more just a letter for clarification? I mean, just thinking of how we're conceptualizing it, it's really, we just want to clarify this and make, you know, as opposed to
Dr. Harpsheets?
we have concerns.
I mean, I don't know what we call it, but I am concerned that people are going to get a misimpression from the statute otherwise. So whether we want to call it a letter of concern or something else, I think we will make the author aware of the problem as we perceive it and ask them to remedy it with a technical change.
So is that a letter? Is that just a letter? A letter of concern, or a letter with those amendments and issues? A letter of issues, is that better? Yeah. Somewhere in between?
I mean, we want to clarify this, you know, that to make it clear that everybody understand that if you're operating in this capacity, so we can call it whatever, as we're talking, but I don't necessarily want to say we're concerned about this, but more
I think we
just
are
want
concerned.
to. I'm not concerned, but I do want to clarify.
What would this type of letter typically be called?
Letter of concern.
You guys must have too many lights on.
Oh.
Okay. Generally, it's just a letter of concern. just raises the flag. We don't get too technical on naming all of our letters. We either have a concern or we don't. Otherwise, it's a letter of support or an official position letter. So, yeah, it's just a letter of concern.
Did we already make a motion?
No one's made the motion yet, but Ms. Marks had her mic lit up, and did she have a comment before?
My only question was whether or not, if the technical amendment was sought and then was made, would the board want to see this bill again to either just review that change or to potentially take a position? If the board thought it might take a position, that might be something that the author would be interested in knowing.
And that's where I would say if you intended to go in the direction of support, that would be different and you might actually take a position. If you plan to just stay neutral on the bill, that would be a difference. So,
I mean, I think it's certainly a great idea to encourage opportunities for registered psychologists and psychological assistants. But from the point of view of being the Board of Psychology, I don't know that we necessarily need to take a position on this legislation. So I would just say the letter of concern, personally, but other people may have other ideas.
Other people with other ideas?
I think at this point the letter is fine, but we might want to take a position later, and we can say that, that we'd like to look at it again or something.
well, it'll stay on your watch list, so you're going to see it
Okay.
again anyways.
Yeah.
As a technicality.
Ms. Sort?
I know this has been an unpopular stance in the past, but I'll throw it out there because it's Friday. The board could also consider a neutral if amended. I know, it's not a popular one, but it doesn't necessarily tie you to a position. It also, I think, makes it a little bit more of a position or a strength behind the suggested amendments or
Does it sound more
technical
ominous
changes.
to you?
I don't know. I'm just throwing it out there. It's not a popular position, but
Just my personal perspective. Sorry, did you want to say something, Dr. Tate? My perspective, neutral with amendments, because neutral suggests you have no opinion or you have no position, but then if you have an amendment, you clearly have some sort of perspective. So it's neutral with perspective just sounds so strange to me, but that's just me.
And if it wasn't amended, then we'd maybe be in oppose or support if amended or whatever. So I think I'd just like to go ahead with a letter of concern.
Can I make a motion?
We have a motion by Dr. Tate.
Subtext, can I go home?
No, just
So we have a motion by Dr. Tate. Go ahead. Sorry.
to direct the staff to write a letter of concern, a letter of inquiry, a letter of clarification, a letter.
We have a motion by Dr. Tate. Do we have a second? We have a second by Ms. Bernal. Do we have public comment related to the item? I see hands raised. Please come forward.
Melody Schaefer, Division 2. With the 500 hours, I think there's a possibility that those hours can count towards their licensure hours, pre-doc or post-doc, if the supervisor or the trainer is a licensed psychologist of record as their supervisor. So if you're going to suggest language that would be a caveat, just like in pre-doc training, we have training hours, and those count if they're under the auspices of such. So maybe something to add to the mix. The other thing that concerns me a little bit is in county and state mental health facilities, if someone has a PSB number, it's kind of a feather in their cap to get funding of various sorts. And what I'm concerned about is individuals, they're psych assistants or registered psychologists, and the only difference is the funding of the agency as to how that gets ferreted out. That one may end up wanting a job for the experience, and your cachet is that you have a PSB number, and that's why they're hiring you, and they may not understand that even if you're not collecting hours, if you were hired under that title, then you have to abide by the regulations unless I'm misunderstanding the regulations. And maybe adding that clarity so that the board doesn't have, unhappy campers down the road that thought they could collect the hours, or some other such situation where they think being hired as a psych assistant but not collecting hours gives them aegis to engage in supervision with that title.
And just for clarification, taking Dr. Phillips' desire to clarify alphabet soup when it comes to things, PSB is our short form for psychological assistants. I still have, to date, no idea why we have PSB to represent psychological assistant, but that is our short form for that when you hear it in reference. Dr. Phillips.
Yeah, I just wanted to say, I think it's pretty clear you can't get hours unless you're being supervised. We don't want this bill to give an impression that you can, but if someone were to go off and use their psychological assistant registration in a capacity where they weren't being supervised in a facility, they'd be in a very difficult situation, let's put it that way.
How would you find out?
Well, we're pretty clear that you have to be under if you're being a psychological assistant.
We're very clear in the room here.
I think the consumer complaint would be the trigger.
If there was a consumer.
If there was a
complaint.
consumer.
But if something came to the board and the student said, well, this was not.
Dr. Schaefer, if you're going to make comments, can you please be at the microphone so we can capture it on the webcast, please?
Sure. We in the room all know that, but in having psych assistants for, 15, 20 years or whatever, and pre-doc interns, it's amazing how much seems as clear to us in the regs as such, and as clear as mud to them sometimes. And sometimes one's interest to kind of feather their nest with more experience may affect their interpretation of what is obvious to us. So I just think for the purpose of clarity and helping students not kind of put their foot in a mud pie unintentionally, to just add more clarity. That even if you take a job, if you're taking the job and being hired under that license, that you cannot, even if you're not collecting hours, still be hired and do that work under that license. Why do I bring this up? I had, for years, issues where MFTs would be hired, MFT interns, and thinking that because they were being counselors, even though they were hired as an MFT intern, that didn't mean they needed MFT hours. All kinds of permutations happen up there around in training. So just as a preventative, I think that would make sense. And plus the issue about the 500 hours that they could count if licensed psychologist that's supervising them provides it.
We're going to go Dr. Harbsheets, Horn, then Dr. Phillips.
I think what Dr. Schaefer is saying, in the past, I've seen this with students who are working in crisis houses in a similar way, and it puts them in a dilemma. They think, well, they have a PSB number, and but then they're doing this work, and when they do apply for licensure, which is what I was saying earlier, they would not really be able to truthfully say, I did not work in a psychological capacity without being supervised, and however it's worded. So I think that's something we do need to think about in terms of clarity, whether it's included in this bill or just when they are maybe checking on what they can and can't do, or letting supervisors know ahead of time.
I'm sorry, Doctor.
A little bit, we're going to clarify. So that's one, and I don't know if we voted yet, but I think we're all in favor of being very clear about if you're doing this, and if you're using this title, you're subject to our regulations. That said, I think both of you are bringing up a larger issue that comes back to things we've talked about before that we're probably going to move more with, and that is supervisors who aren't maybe adequately supervising and adequately informing the people they are supervising about, what the requirements are and stuff like that. So that's kind of on our radar, but I think that's what I'm hearing from you two, and just want to.
And ultimately, it is a consumer protection issue.
But I have a twofold response, which go in either direction. One is, I don't know where someone under our regulations would get the impression, if they were a psychological assistant, that they could operate independently as a psychological assistant. I think that's very clear in the regulations. Whether people bother to read them or not is another question. That does not mean, however, it wouldn't be worth making some educational efforts to remind people of that. But at some point, it's your responsibility to know what your registration allows you to do.
Dr. Winkleman
to play devil's advocate, and then I'll go
Hold on,
away.
I also want to respect that Dr. Winkleman has been there for public comment.
She's
Okay.
conceding her moment for me. Thank you, Dr. Winkleman. To play devil's advocate, the student that says, well, I wasn't collecting hours, so why is that relevant? I am a psych assistant. This is the issue I was trying to illustrate, as someone that, yes, I read the regs, but if I'm not collecting my hours, why is this an issue? And when you read the regs, it doesn't exactly state that, at least in any of the iterations I've read, clearly, that even if you're not collecting hours, if you're working in a position where you're using that title or hired under that title, that one is mandated. Now, it seems silly because we all understand the spirit of the regulation and what is meant by that. But I don't want to belabor the issue if you don't think it's necessary. It's just that would be my one concern. Having been in the field with doing training and a lot of it and supervising and seeing distortions in understanding, not necessarily intentional, but just to abate that if it's possible. Thank you, Dr. Winkleman.
Okay. Hi, Elizabeth Winkleman with California Psychological Association. Just a couple of points I wanted to make. CPA does support this bill. I appreciate the intent of clarifying some of the issues here. I also just wanted to mention that also the main intent of this is to expand access to services and expand the kind of services that are going to be covered, and also provide potentially more roles for psychologists, psychology trainees, and people interested in psychology. I believe there may also be a consumer protection aspect regarding minimum qualifications as well. I'm not sure. The one thing I wanted to clarify on, and forgive me if I haven't followed exactly the discussion on it, but I also think that it would be possible for the psych assistant or registered psychologist to get SPE hours while they're getting the 500 hours, if all the other requirements for SPE are fulfilled. So just wanted to think there was a little confusion about that, but I would think it would make sense, and just wanted to get clarity on that too.
Any additional public comment? Seeing that, I'm going to bring it back to the board. Do I see additional discussion from the board here? I know Ms. Sorick just mentioned that we could include in the letter Dr. Winkleman's comments about those hours for that. So we have a motion by Dr. Tate, a second by Ms. Bernal, and seeing no further discussion, Ms. McCorkin.
Tate? Aye. Harbsheets?
Aye.
Akwe-Badu?
Yes.
Phillips?
Aye.
Fu?
Aye.
Bernal? Oh, I'm sorry. Horn?
Aye.
Bernal?
Aye.
Motion passes.
Thank you. This concludes the report of the Legislative and Regulatory Affairs Committee. Oh, actually, no, there's one more, but sorry. Yes, Ms. Sorick?
Really quick, I just wanted to clarify for the letter of concern, it will touch on 2 points. One, that the psych assistant or the registered psychologist would be required to be supervised per our law, our licensing law. And then the second, if the 500 hours are obtained under the supervision or provided by a licensed psychologist, those hours could be used as supervised professional experience. I just wanted to clarify those 2 points. Okay.
So the last item, Senate Bill 201, this is a bill by Senator Wiener that would, absent of medical necessity, prohibit a physician and surgeon from performing any treatment or intervention on the sex characteristics of an intersex minor without the informed consent of the intersex minor.
Originally, staff had requested that we watch this bill for potential issues regarding psychological evaluations or referrals being incorporated into these guidelines. However, the bill is now a 2-year bill, and so will not be moving forward. So if there's no further discussion on this bill and no action taken, is there public comment? Seeing and hearing none, this concludes the report of the Legislative and Regulatory Affairs Committee. And I'm really eager to close out the report. So item 23 is legislative items for future meeting. Any items from the board or from public comment related to legislative items? Seeing and hearing none, that concludes item 23. Mr. Chair, Mr. President.
Okay. So the final item on our agenda before we adjourn is recommendations for agenda items for future board meetings. Again, we can't discuss them, but if somebody wants to suggest a future item, we're happy to put that on the agenda. Hearing none from the board or the public, I think we're ready to wrap up. Would somebody like to make a motion to adjourn?
So moved.
Second. All in favor can raise their hands. We're going home. Thank you very much.